Good morning. I'd like to go ahead and call to order the September 18, 2018 meeting of the Indian River County Board of County Commissioners. We will begin with a moment of silent reflection for our first responders. And then I'd like to invite Stan Bowling, the Community Development Director, to come to the podium. He'll lead the invocation, and that'll be followed by the Pledge of Allegiance led by Commissioner Joseph Flesher. Would everyone please rise?
Lord God, this morning we recognize that you are in charge and we are not, and we are glad for that. And we're also aware that you give us some authority to be and do what you want done. We're also, as a community this morning, mourning loss, and we're also experiencing hope in life. And we have neighbors to our north who are experiencing loss and many challenges, and yet there are many that are trying to help. We ask that you would motivate, that you would strengthen, that you would encourage all those who can help to give comfort, to give relief, and to bring forth life. We ask that in the decisions that this board has this morning, that you would allow them to be used by you and make wise decisions. And again, Lord, please point out to us this morning, this week, where you want us to provide comfort, where you want us to provide help. Thank you for the ability to be involved. It's in your name we pray. Amen.
Amen.
Ladies and gentlemen, please include in the Pledge of Allegiance to the greatest nation on earth, the United States of America, land of the free and home of the brave. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Stan. Take a second here, since we have a good crowd, to announce that tomorrow night at 5:01 p.m. is our final budget hearing. So we hope to see everybody that's here this morning to be here tomorrow evening for the budget. Under changes, deletions, Commissioner Solari, I would assume you'd like to move your item up to follow the public speaking item. Is that correct?
Yes, move 14B to follow 10B1, please.
Okay, so we will do that. And then I've had a request from Judge Cox. She has a jury waiting, so if we could move her item 9A to immediately follow additions and deletions. Is there any other changes to the agenda?
Move the agenda as amended.
Second.
Thank you. We have a motion from Commissioner Solari, second by Commissioner Flesher. All in favor signify with aye.
Aye.
Any opposed? That carries 5-0. So now we will move to 9, constitutional officers. Judge Cox. Good morning, welcome.
Good morning, members of the Commissioner. I think the request for an award is self-explanatory. I really just wanted to be here to answer questions. As you know, these funds are derived from assessments against drug offenses. That trust fund was created. It's the Indian River County Substance Abuse or Substance and Alcohol Trust Fund was created to assist those that need drug testing and drug treatment, as well as alcohol testing and treatment. I'm applying on behalf of all three of our problem-solving courts. That's the drug court, the Veterans Treatment Court, and the mental health court, for individuals that cannot afford their testing and treatment. And we found that this testing and treatment is paramount to the success of their sobriety and their graduation from the programs. And there's many individuals that have not been able to participate in primarily the drug and Veterans Treatment Court programs because they couldn't afford that. So with that, I'll...
Judge, thank you. We have a motion from Commissioner Flesher, second by Commissioner Zork. Judge Cox, I'd just like to say I think we all greatly support the work you all are doing with the mental health court and the Veterans Court and the drug court. I would just point out that currently at this rate, we're spending more than that's coming in. We still have a healthy balance, but maybe some point down the road we might have to kind of
I understand
look at balancing it out, but I certainly have no problem moving this forward at this rate now.
I think we have 10 years to figure it out.
Well, probably a little longer than that,
Yeah,
but,
because it is increasing by about 10 to 15,000 a year.
right, so, but that, I think it's well worth it, and I'm very supportive of it, so.
Thank you.
We have a motion from Commissioner Flesher, second by Commissioner Zork. Is there anyone from the public that wishes to speak on the motion before us? Seeing none, all in favor signify with aye. Aye. Any opposed? That motion carries 5-0. Thank you, Judge.
Much, and thanks for letting me skip.
No problems, thank you. So moving back, proclamations and presentations. It is certainly an honor for me to read this next proclamation. And we'll be honoring Corey Sanford Richter on his retirement from Indian River County Board of County Commissioners, Department of Emergency Services, with 25 years of service. And we were able to talk Mrs. Richter into coming up with you now.
Thank you.
Corey, let me read this, and then we'd certainly like to hear a few words from you, okay? This is a proclamation honoring Corey Sanford Richter upon the occasion of his retirement from Indian River County Emergency Services. Whereas Corey Richter began his distinguished career in public service with Indian River County as a paramedic on January 11, 1993. And whereas he rose steadily through the emergency medical service ranks by making lieutenant in 1994, captain in 1997, and becoming the EMS Deputy Chief of Quality Assurance in 2001, which, upon consolidation with Fire Rescue in 2006, ensured his easy transition to dual certifications, resulting in his final promotion to Assistant Chief of Indian River County Emergency Services District. And whereas Chief Richter is known in fire rescue for being a master mediator and collaborator, he holds numerous prestigious local and state awards for selflessly investing a tremendous amount of professional and personal time to support his colleagues and bring organizations together. And whereas he is well known on a national level for his work on the Florida EMS Strategic Vision Plan, making strides with consistency in communication, standardization, gathering of information, and simplifying the process through collaboration while achieving zero redundancy. And whereas Corey Richter, Assistant Chief of the Emergency Services District, is retiring on September 28, 2018. Now, therefore, be it proclaimed by the Indian River County Board of County Commissioners that the board appreciates Corey Richter's efforts on behalf of the county and wishes to express our deepest gratitude for the 25 years of dedicated service he has given to our citizens and 36 years to the EMS profession itself. And be it further proclaimed that the Board of County Commissioners, staff, and coworkers extend their sincerest wishes for success in all of your future endeavors. Adopted this 18th day of September, 2018, signed by myself as chairman of the Board of County Commissioners of Indian River County, Florida. Corey, it's been a distinguished career. I don't think we can thank you enough for your service to the community, and we hope that you two have some great plans in the future and a lot of honeydews around the house, I'm sure. But tell us a little bit about what you're going to do here, Corey.
Well, thank you again. It's an honor to get this proclamation from you guys today. And first, I'd have to really thank my wife and my family for the support throughout the years. And of course, your support and fire rescue support for everything that I've done. I did a lot of travel and stuff, but it was all for the betterment of EMS nationwide and statewide, you know, for the future of EMS and stuff. And that's what my vision was always looking out for the guy that's starting today and what the future is going to be for them. And it was really an honor to do it. I'm still going to be doing some stuff. I'm on a national committee that I'll still be doing some national stuff, so I'll still be busy. doing stuff, and I'd love to, wish I could stay with the way things are going now in the county. Here, Chief Stone has really turned the place around morale-wise, and see a lot of great things coming from him, and with the support from you guys, it's just going to get better and better here. It's truly been an honor serving the citizens and serving the commission, and I appreciated all your support throughout the years. So, thank you.
Right. Chief Stone, anything you'd like to add?
Besides the fact I'm rescinding his drop and putting him back to work,
I think we can do that.
I think the county manager just gave a big twitch. No, actually, I need to get him back to work. He's leaving in 2 weeks, and he's got about a month's worth of work to get done before he leaves. It is nice to come into an organization and have somebody that has the organizational history and knows where everything is and knows what has to be done. And you can rely on them to have those open, frank conversations, and that's what Corey and I have been able to do. We can look at each other and go, nah, it ain't gonna work. And we both understand where we're both coming from. So it has been a true pleasure to have him as part of the management team. Thank you.
Very well. Well, Corey, again, we appreciate all your efforts and dedication to the community. Jason, you had a comment, please?
Sure. Thank you, Mr. Chairman. Just wanted to say thank you to Corey for all your years of service. Corey has been a team member and a collaborative effort his whole career. He will be missed. We talked about how he's helped out nationally and across the state, but right here in Indian River County, he's made a tremendous impact on the services that are provided to the residents and to the department itself. Just one of the many things that he's responsible for. Corey, we need your help. We can't have any more hurricanes after September 28th because Corey does a lot of things, but one of the things that I'll remember him most for is helping out during the storms. There is quite a symphony that goes on to get the special needs shelter up and running, collaboration between fire rescue, the health department, SRA, the school system, our own lifeguards, everybody that comes together. It's quite amazing to see that work out. And not everything goes right all the time. We have great plans, but whenever you're working on something like that, nothing goes quite according to plan. But Corey is somebody who made sure that things happened and got things taken care of. So I'll definitely remember that. And no hurricanes this year. But thank you for your service throughout the years and everything you've done for the county.
Special needs, I got to say, that was a collaborative effort between Miranda and myself.
Very good. Commissioner Flesher.
Thank you, Mr. Chairman. Corey, it was a distinct privilege and honor to work with you on the job, off the job, clam bake, soccer field. I mean, you were ubiquitous. You've done so much in this community that you're going to be sorely missed, maybe here on the job, but you will not be missed in those other factions because I know you can't just give it all up. So we really appreciate that. For everybody, we can give you Corey's public shopping day. This way you can see him and ask him anything because, quite frankly, the one thing I think about when I think about you is, and stems back to the hurricanes, is approachability, availability, and those are definitely your earmarks. You've always been attentive to others' needs, and you were not distracted from being a true friend and a professional on and off the job. Thank you so much. Accolades to that young lady who sacrificed so much for what you did.
She's put up with me for 36 years, so.
Commissioner Zork.
Yes, Corey, was great working with you over the years, and I'm sure there's one thing you won't miss is when I want to review response time, out the door time, those lengthy reports, but
I can't disagree.
you just forgot, just happened to pass on, but
Dr. Steve Greer. I'll give you his card.
I think, and when the 2 weeks is up, I think without too much nudging, Ed will share with you his fashion advisor of how to get into full retirement garb.
Well, not just the retirement, but the nap scheduling is critical.
Right, right. He has an app for that, I believe, that reminds you when to take your nap. But thanks for all the service over the years. It's much appreciated. And when we go through our next hurricane event or special event without you, we'll surely be missed. But thank you for your service.
I'll be turning my phone off now.
Corey, thank you.
Hey.
One for the office, one for the car.
Hey, Corey, thank you so much. Let's give another one. Here.
Next on the agenda is a presentation of a proclamation designating September 17 through 21, 2018 as Industry Appreciation Week in Indian River County, Florida. This will be presented by Commissioner Flesher, and we have quite a host of industry folks here, so you all come on up. We have Helene Castletine from the Chamber, Mark Seberg with Berkshire Hathaway Home Services, Christy Schwartz, Summit Construction, Lynn Fisk, EGP Document Solutions, Alphonse Alexander, Alexander Insurance Company, George Watson with Seacoast Bank, Jim Funk, Piper Aircraft, Robert Paw, Bill Bryant and Associates, Andy Beindorf, National Bank of Commerce, Karen Deagle, Senior Resource Association, Bart Getjens, External Affairs Manager with FP&L, and Ross Cotherman, Principal with Raymond Robinson. And anybody else that I missed? Oh, and our new Chamber Executive Director, Dory Stone. Good morning, all. Welcome. Commissioner Flesher.
Good morning. Mr. Chairman, thank you so much for the opportunity to present this proclamation to a recipient that, and you could check Wikipedia, is synonymous with industry in Indian River County. So thank you for being here and bringing this great cast. Let me go forward with the proclamation. It designates September 17th through 21st, 2018 as Industry Appreciation Week in Indian River County, Florida. Whereas business and industry in Indian River County is increasingly vital to the health of our entire county. And whereas while our local economy continues to strengthen, the sustainability of Indian River County's existing industries is key to a prosperous future. Whereas the future expansion of those industries will account for the majority of new high-wage and high-skilled jobs created in our county. And whereas our existing industries help sustain and improve our quality of life by diversifying and strengthening our tax base in Indian River County. And whereas an Indian River County Chamber of Commerce serves as the county's primary economic development organization, providing support for the retention and expansion of local industry. And whereas public awareness of the contributions made by industry is essential to the maintenance of good community-industry relationships. And whereas Indian River County government recognizes the achievements of our local businesses and industries and the positive impacts made. And whereas all residents are encouraged to take the time to salute Indian River County Industries and their employees for the contributions that they make in our community. Now therefore be it proclaimed by the Board of County Commissioners of Indian River County, Florida, that the week of September 17th through 21st, 2018, be designated as Industry Appreciation Week in Indian River County, duly adopted this 18th day of September 2018, signed by all 5 county commissioners. Good morning, Helene.
Good morning, Commissioners. For the record, Helene Castletine, Economic Development Director with the Indian River County Chamber of Commerce. Thank you so much for giving us time on your agenda today, and thank you for joining us in honoring and recognizing the importance of industry here in Indian River County and how much it helps our local economy. And I do have a good support group with me here today. This is a very special year for the Industry Appreciation Awards program in that we are celebrating our 30th anniversary. So starting in 1988 is when the first awards program took place. So Thursday, our awards luncheon is scheduled. It is a sold-out crowd, as it is every year. We will be handing out 24 awards to local companies, recognizing them for either architectural enhancements, industry success, or their community involvement. So we continually thank you for your support and everything that we do as it relates to economic development. And we look forward to another successful year. So thank you very much. We appreciate this.
Well, thank you for what you all do.
Thank you. And I did want to mention that our committee chair, Anna Valencia Tillery, could not be with us this morning. She's with White Glove Moving, Storage, and Delivery. So in her stead, we have the president of White Glove Moving, Storage, and Delivery, Mr. Caleb Clements, is here to support our program and support the chamber. So, at any rate, thank you very much for everything that you do to help us in economic development.
Thank you.
There we go. Thank you.
Thank you once again. Thank you, Helene. Thank you. Thank you. Yes. Thank you. Thanks for taking the time to be here. Go get some more jobs. Sir. Good to see you, Andy.
Morning. Morning, everybody. Morning again, everybody. Good to see you, as always.
You're the only one that's eye to eye right now. Thank you. Thank you again. Thank you.
There are no minutes for approval, so that moves us on to the informational items. Just like to point out, we do have a retirement. Jim Hargraves is retiring from the Department of Utilities with 25 years of service. So Jim, thank you for your dedication and service to the county. Commissioners, does anybody else wish to comment on an informational item?
You know, biosolids?
It's all about the poop. Thank you. Moving on to the consent agenda. Commissioners, does anybody wish to pull a consent agenda item for additional discussion? Is there anyone in the public that wishes to have a consent agenda item pulled for additional discussion? Seeing none,
Move
Commissioners?
approval as written.
Thank you. We have a motion by Commissioner Flesher, second by Commissioner Zork. All in favor signify with aye. Aye. Any opposed? That carries 5-0. We have already taken care of item 9, so we now move to Item 10, public items. First is a public hearing. This is a consideration of land development regulation amendments to chapters 911, 12, 13, 14, 15, and 972 regarding a whole bunch of land development regulations. And with that, I'll turn this over to Community Development Director, Mr. Stan Bowling. Good morning, Stan.
Good morning. Thank you, Mr. Chairman. There are a lot of regulations in this particular set of proposed requirements, and these have been reviewed by the Development Review and Permit Process Committee. And I did want to point out that the chair, Deb Robinson, is here in the chambers this morning. If she wants to comment. Just a summary, this set includes 6 separate ordinances, and each focuses on a particular process or topic. And 5 of the 6 ordinances are based on recommendations from the Development Review and Process Committee. And another one is staff has kind of piggybacked on with those. The first installment of code changes recommended by the committee you all saw back in March and approved, and some of those kind of improvements to the process are already in place, and we think that this set of amendments will have some more process improvements. I would like to just go through the ordinances with some of the highlights. The first ordinance deals with affidavit of exemption review. Those are for large lots, 5 acres essentially or larger. And the requirements that we think will make a lot of sense and actually speed up the process will be to require a single recordable map. It's similar to a final plat, not exactly the same. And that will keep us from having to review and have an applicant produce numerous other documents that would otherwise have to be filed. So we think in the end it'll be an easier product also to use for property owners and future folks that have to look at what's being created. So that's been supported by staff and the Development Review Committee, as well as the Planning and Zoning Commission. The second ordinance deals with our final plat review and approval process. The first item is actually an item that I think back in January you all approved to continue to require here in our own code a Florida licensed attorney rather than a title company with limited exposure to back up title work on a plat. That's also been supported by the committee and the Planning and Zoning Commission. Other items we think will save some time in the final plat process. A checklist has been prepared by the county surveyor and is part of the submittal process for an applicant. Authorizing a kind of a stop-loss comment if there are grossly deficient submittals. That really gets to one of the approaches I think the committee has backed, and that is for applications that are complete and responses are complete. Those are going to go through the process faster. And if we have a situation where we have a very deficient submittal, stopping that review and just having that person resubmit. And I think that'll be good for all parties involved. It also provides an option for developer to have an agreement, security agreement structured that can automatically convert construction security to warranty maintenance security, so that authorization will be in the code with this change. We also trimmed some of the costs off of warranty maintenance security, some of the soft costs, surveying and engineering that wouldn't be needed at that point in the process. And we also clarified a couple of items. The attorney's office and planning staff also took the opportunity to coordinate with the clerk of the court, and they've been really helpful in updating some format things in final plats. We think that'll be an improvement. So that change is also supported by staff and the review committee. Another ordinance deals with master lot drainage plans for new subdivision projects to require that at the time of land development permit. It's reviewed by Public Works. And we think this will pay big dividends down the road when single-family building permits come in and there's already a lot drainage layout that an applicant can plug into. With the board's authorization, staff would like the board this morning, actually, if you could, with the motion to waive the administrative approval fee for any developer of an active subdivision that wants to go through and voluntarily do that master drainage plan to amend their LDP that's already been issued. We think that'd be a good incentive for the board to consider this morning. Another ordinance deals with affordable housing project conceptual plans. There have been some issues with the way that the state grants are set up. If you have a conceptual process in place in your local government, An applicant really needs to go through that process before they can even file for a grant application. We've gotten feedback from applicants. It'd be nice if they could have a trimmed down conceptual plan, taking on the risks that they'll be going through the full process if a grant is awarded. And so those changes are in ordinance number 4. We think that'll help affordable housing and workforce housing projects. Those ordinances are also supported by staff and the review committee. And just looking ahead, just got 2 more to go over. Ordinance number 5, early model homes on subdivision construction sites. This actually sets up better and more specific standards for what needs to be in place during site construction for a subdivision before an early model can start, vertical construction can start in terms of access and firefighting capabilities, essentially, as vertical construction goes forward. And it also opens up a little more flexibility for more early units to get started with this change, with those kind of access improvements in place. That's supported by staff and the committee. And the final one is one that staff is kind of thrown into the mix. It's a side yard setback allowance, a relaxation of our normal setbacks in the medical district. We've had good success over the years with this allowance, which is in place in other commercial districts where you may have multiple lots in a development with interconnected parking, and the sites really share and function infrastructure to allow a 0 setback for buildings. This is an example from a commercial district where the 0 setback is allowed. And in these places, no one can actually see where the property line is when you're out there with the development. There are usually cross-access agreements and so forth with shared infrastructure, and just give more flexibility in our med district. And we're seeing more infill in our med district now, so staff would recommend that you all pass that change as well. The Planning and Zoning Commission looked at all these changes and voted 7-0 to recommend that the board adopt those ordinances. Staff's recommendation is that the board adopt the 6 ordinances and also authorize staff to waive the administrative approval fee for developers of previously approved and active subdivisions if they propose a master drainage plan for remaining vacant lots. Those are just the highlights, but I'd be glad to try to answer any questions that you all might have.
Very good. Commissioners, any questions of staff? Commissioner Zork?
Yes, under 1C, under the model, being able to start construction on a home before the subdivision is complete, we now have added 1C, water for firefighting must be available. That is a new requirement, and just to kind of put it into context, that would mean you couldn't put a shovel in the ground until you have DEP sign-off on your water line to have active hydrants in the neighborhood. So you're looking at taking whatever the prior construction timeline was and adding potentially a number of months before you could actually start. A lot of places have the DEP sign-off, the neighborhood's complete, and they'll have their 2 or 3 model homes ready, open, finished for the public. This now puts that activity before they can even start construction much further down the road. So I don't know if we could ask a question of the chair of the committee obviously the committee moved it forward, but it does extend the timeline, which extends the holding costs for interest and all those other things that go along with that. Good morning.
Good morning, Deb.
Good morning. Deb Robinson, Laurel Builders. We discussed that at the committee meeting, and ultimately it was determined that it was really generally it's difficult to build a house when you don't have any roads, at least the base finished, and by that time you've got your utility lines in and very likely the water approved. But the committee felt from the development and community and construction side of the table that this was a positive move. It was correct.
Okay. From the designation so you can sign off your DEP sewer and water separate, so you don't have to have sewer capacity. It would just be water capacity.
They just want to make sure that there's fire protection available.
And how do we treat this when it's a 5-acre ranchettes where there's no water within miles to them, or some other type of location where, I mean, we issue building permits on houses every day that don't have a water line in front of their property or a fire hydrant in their neighborhood. So it's kind of putting an extra burden on the newer subdivisions versus the older ones that don't have that.
That's a good question. I mean, beg pardon? That issue didn't come up. We didn't discuss that.
No? Okay.
In general, we were looking at the logic. What we're trying to do is go over the development regulations and try and streamline things and put a logic to it, and not just react to issues that have happened when it's in the front page of the papers.
Right.
In that process, this came up, that came up, and we were trying to come up with a comprehensive approach that was logical and made sense. You can go in, when you're building a subdivision, you can go in and build model homes. And the idea of getting a home built quickly is wonderful, because then you can market it.
Right.
But the truth of the matter is, trying to build a house without water is really difficult. So if we don't have access to the water, you've got to import it. And if you don't have some sort of road system or base to get it in there, it's very complicated. Not too many people want to go that route anyway. So it just seemed to make sense at the time to put a timeline in so that you needed to have some basic services available before you went charging forward.
Right. Okay. As long as, I know in the past, we just want to make sure staff knows, and I think they do because they were part of this, that when we want to get an early DEP sign-off on a water line, and there's still a lot of other things to be done, that the importance is maybe to get the model homes started under, that we need fire flow, and you can only get that through your DEP sign-off. So once those are submitted, we would just hope they go through the process as soon as possible, so that if somebody's wanting to start models.
Yeah, I mean, some of these things, you don't really know what you're going to come up against until you come up against it, but I think that's a great comment, and it's something we can discuss at the committee meeting tomorrow. Bring it back up again, and Jason?
The line in the ordinance says per section 9130916, and if you look at 9130916, it says fire hydrant system shall be provided in all subdivisions served by a water system. So I'd say the 5-acre affidavit of exemptions, I'd say it's less common for model homes in those, but to
Probably.
the extent that there would be, if it's not served by a water system, I think that that requirement would not apply, it would seem.
Okay.
That is correct, if I could.
Yep, Stan?
Also, two other points, that's correct. The 5-acre subdivision is probably going to be affidavit of exemption and not served by water, so that, and you're, Jason is correct, we don't tend to get the early model requests with those. The other two other items that the committee did discuss, and the chair has brought this up. What we're trying to do is also make sure we don't set up, or we try to eliminate potential conflicts that we've seen in practice sometimes between site development and vertical development, and people getting in the way, and having some of the basic access and water there for some of the what's really needed for good vertical construction. But there are cases where you could have a fire hydrant along, say, a collector road right near the entrance of the subdivision, and actually you might be able to get an early model or two close to an existing fire hydrant that's not actually internal to the subdivision, which would be a logical place to maybe get a start as well. So that could also happen. But again, the committee, I think, was looking also at conflicts that can happen if you're not far enough along with infrastructure when the vertical starts, because it's, site contractors and the vertical construction builders tend to be in different worlds.
And also, not in this particular section, but the ability to bond off your plat improvements so that you can start construction on pre-sold homes, that's also changing? No? I've just got a comment from somebody that had said that there was a change that you couldn't, right now you can bond off your plat, get your plat recorded, submit for building permits.
Right, so,
You'll still be able to do that.
yeah, that's correct. The last 25%, you can still bond out for and get your final plat approval.
Oh, you know what they're talking about. Here's the deal. This is in response to what happened on, what
Right.
road is that? Where they
Millstone.
didn't move the electric lines.
Oh, Millstone?
Millstone.
Didn't do the turn lane. Anyway, you have been able to bond out improvements and proceed. The problem is, if you then don't do what you said you would do and complete the improvements, then the county doesn't want to be in a position to pull a bond and go into construction, because that's not what they do well, you know? That's what we do well. So in an effort to control that, you can build in a subdivision up to the point where those improvements have to be, where the improvement, for instance, if you need a turn lane, you can only put in a certain amount of units until that kicks off the need for the turn lane. Then you can no longer bond the improvements and proceed. You must put the turn lane in. That's what's changed. It's just that it's forcing the improvements at the time that is necessary.
Did you guys address who's responsible? Let's say if the county's responsible for procuring the right-of-way for the turn lane, and that hasn't been completed, well, those are rare exceptions. We don't need to get.
Well, and it's kind of like, we talked about a lot of different issues, and Stan said, yeah, and the cat ate your homework.
Right.
And that's, I mean, you can't legislate for every single potential. You have to have a working relationship with staff and hope that we can work things through, and ultimately, there is the board.
Right, and I know if you're happy with these, other people are happy.
Well, there's that. I mean, you know, I'm never.
Well, I know, because
happy.
you're a tough cookie on these things, so if you're good with them, and I've tried not to meddle with the committee, talk to the committee members, and just save the discussion for when we're in a public environment, so.
No, I think it's been an excellent example of a partnership between the development and construction community and staff. And I think we've made efforts to streamline things. I mean, sometimes the two different sides always kind of get an adversarial relationship. Working together has been, I think, a very positive movement. And we've come up with things that we hadn't really, neither side had thought to do. So I think it's helped the process. It's provided accountability for both sides. It's set up some, for instance, we would always complain about the length of time it took to get a permit. But a certain amount of people turn in incomplete applications. Well, you know, from your own position, from business, the more times you have to touch something, the more money it costs. So now we don't accept incomplete applications.
Good.
So that's not wasting a bunch of time for the staff. It's also not incurring the need for additional staff that we would have needed because of all this workload that was useless. So looking at it from both sides has been very beneficial.
Good. Thank you.
And I appreciate staff. They've really done a great job.
Any other comments from the commissioners? Seeing none, this is a public hearing. I'll go ahead and open the public hearing. Is there anyone from the public that wishes to speak on these land development regulation amendments? Good morning, welcome.
Joseph Paladin, President of Black Swan Consulting. I'm also Vice Chair of the committee that Deb Robinson just spoke on. I support everything she said. And one of the things that we might take in consideration, because we had a big array of different types of businesses represented on the committee, all these things that we voted on went forward, we voted on unanimously. So we're all in full agreement on the points that were just brought forward with staff. I think that's important. What we basically tried to do is streamline the system and solve problems we had. We really didn't spend a lot of time on trying to solve problems that weren't there yet, because that was kind of a hard thing to try and put together on some of the questions that Commissioner Zork brought forward. But everything was approved unanimously, and I think that's a good point, and I support everything Deb said. Thank you.
Thank you. Is there anyone else from the public that wishes to speak in the public hearing? Seeing none, okay, I'll close the public hearing. Stan, could you just put back up the last slide with the staff recommendations, please?
Yes. So the recommendation is to adopt all the 6 ordinances and authorize staff to waive the administrative approval fee for developers who previously approved and active subdivisions proposing master drainage plans for remaining vacant lots.
Thank you. So Commissioner, it's your pleasure.
Move staff recommendation.
We have a motion from Commissioner Zork, second from Commissioner Flesher. All those in favor signify with aye.
Aye.
Aye. Any opposed? That carries 5-0.
Mr. Chairman,
Commissioner Slurry.
so one question for Stan. So Stan, does this mean that we can now sunset the committee?
The committee automatically sunsets in next month. So they have tomorrow's meeting and then their meeting in October. And unless the board extends it, they will sunset.
Well, if they don't need the meeting in October, we can sunset early. That'd be fine.
I think they will. I think they'll need the meeting in October.
Cost factor.
That's, they still beat the, you know, it's good to set the.
Oh, boy. Okay, moving on to item 10A2, another public hearing, the consideration of a land development regulation amendment to chapters 911 and 971 regarding the review and approval process for places of worship. This is legislative in nature, and again, welcome, Mr. Bowling.
Thank you, Mr. Chairman. This really is an initiative of the Board of County Commissioners. The concept was presented to the board by the County Attorney's Office in March of 2016, really for legal and case law related reasons. And staff had anticipated pairing this with any other LDR amendment that might require a change to a use table, because that has a different process to follow. But that hasn't happened, so we thought, well, we really need to bring this forward. So we're bringing it forward along with the other LDR amendments, although it does have another step that I'll describe in a moment that will need to be taken. Currently, we don't have any place of worship applicants in the formal review process. We've had several pre-applicants. Potential applicants go through the pre-application conference, and we've notified them about this potential change, which would streamline the process for approving a place of worship development. Again, it changes the use classification in several zoning districts, and that requires 2 public hearings before the board. This constitutes the first hearing. One of the 2 hearings must be held after 5 p.m. unless 4 or 5 of the board members vote to hold both hearings before 5 p.m. So you all will have that decision to make toward the end of this hearing. Just a bit of background again. Places of worship review and approval process. The proposed ordinance would change the use classification of place of worship in several zoning districts where it's currently a special exception use to an administrative permit use. The differences being there would not be a public hearing before the Planning and Zoning Commission and the Board of County Commissioners. There would be review and approval before the Planning and Zoning Commission as an administrative permit use. And the result would be that there would be no special exception use approval in any of the zoning districts for place of worship. But again, it would be a type of conditional use that would have the same special, basically setback and location and buffering requirements that we have now, except for the locational requirement. Right now, it's a pretty subjective locational requirement in there. We have drafted more objective criteria, which we think will be a good step going forward, not only for staff, but for applicants and potential neighbors as well. The objective standard that we're talking about is for the location and traffic. The proposed criterion would be based on the number of project trips and the project site's road frontage, land use designation, whether or not it's in a planned development. And the new criteria would be consistent with all the past approvals the board has made over a number of years for places of worship, where they're allowed on local streets if they're small in scale or located within a higher density zoning district. Otherwise, they need to come off of Collector Road or higher. And that's exactly the practice that the county has essentially implemented for a number of years. This is supported by the county attorney and staff, and again, it's been initiated by the board. The Planning and Zoning Commission reviewed this and unanimously recommended that the board adopt the proposed ordinance. Staff's recommendation is that the board direct staff to make any necessary changes to the ordinance, and if you're so inclined, by a vote of 4 or 5 board members to set the second final adoption hearing. We could set it for the regular meeting of October 16th at 9 a.m., and you all could announce that if that's your pleasure. Be glad to answer any questions you might have.
Stan, Commissioners, any questions of staff? Seeing none, this is a public hearing. I'll open the public hearing. Is there anyone from the public that wishes to speak on this item? Good morning and welcome.
Good morning. Bob Johnson, Corwin Subdivision. What examples, Stan, have brought about the need and the necessity to change the existing ordinances as they are now? If there's no in the pipe, there's no need to make any changes to the existing ordinances.
Mr. Johnson, I think Dylan will.
Yeah, Mr. Johnson, I will tell you, actually, the issue didn't really come from an issue here, but it's really from an issue of case law. What has recently happened within the Southern District of Florida is that there's been a ruling that churches and houses of worship cannot be dealt with reviewed in a subjective manner, such as a special exception. So in order to comply with the federal law, we needed to make sure that we had these types of uses that were reviewed through an objective criteria. And I just want to thank Stan and his staff for coming up with some good objective criteria to make sure that we were following consistent with the law.
So what you're saying now is that our existing ordinance is not in compliance with the...
Arguably, a review of a church through a special exception process would be in violation of the federal law. So we're just trying to make sure we're keeping up to date with the federal case law.
The concern is the violation of our religious rights as citizens to have free speech, worship in accordance with the guidelines that we all have under the Constitution, and I'm not sure that this doesn't impact that in some way.
Bob, actually, this makes it easier. Just administrative approval is a much easier process than going through a special exemption, public hearing, and the documentation and everything. This process actually streamlines it and makes it easier to go forward. I would say 100% it's not infringing on any religious First Amendment rights at all.
Well, are we changing our, Stan, give us an example of what may be changed here if you would, please.
Sure. So mostly what's changing is the process. There will be less discretion on the part of the county to approve or deny an application for a place of worship. In fact, it would have to be failure to meet an objective criterion would be the only basis for denial. Again, we've not had any problems here in practice, but the case law is such that any discretion that a local government would have could violate a First Amendment right. So this is really just changing the process and making it easier for applicants.
Well, right now, there's certain requirements for bars, the distance between bars, I believe, and churches and what have you. Is that going to change?
That's not affected, and in fact, we do not have, in the unincorporated county, we do not have a separation distance between places that have an alcoholic beverage license and places of worship. Places of worship are allowed to go right in beside a bar and in commercial districts, so it's all pretty open. This doesn't change any of those requirements, just the process for approving a new place of worship.
Thank you very much.
Thank you. Is there anyone else from the public that wishes to speak to this? Seeing none, I'll close the public hearing. Commissioners, I'd like to do this in two motions, just so we kind of keep it clear. So the first one is, are there any changes to the proposed ordinance, or is there a motion to move the ordinance forward as presented?
Motion to move forward.
We have a motion from Commissioner Flesher, second from Commissioner Adams to move the ordinance forward. All in favor signify with aye.
Aye.
Any opposed? That motion passes 5-0. And then, Commissioners, do we wish to set the second and final public hearing for October 16, 2018 at 9 o'clock in the morning?
So moved.
Second.
We have a motion from Commissioner Adams, second by Commissioner Slaughter, to set the second public hearing for October 16, 2018 at 9 a.m. All in favor signify with aye.
Aye.
Aye. Any opposed? That motion carries 5-0, so therefore it meets the 4 out of 5 requirement, so we will set that public hearing for October 18. Thank you, Stan. We now move on to public discussion items. The first one is a request to speak from Betsy Biggins. Okay, I'm sorry, my apologies. Regarding request for anti-chaining ordinance for dogs and cats. And we did approve earlier. We will also move up Commissioner Slaughter's item 14B1 to tie in with the presentation. So with that, good morning, welcome. If you would give your name and address for the record, please.
Good morning, my name is Betsy Beggins. My address is 3200 Eagle Drive, Apartment 2, Vero Beach, Florida, 32963.
Thank you.
And I actually am a landowner, a property owner. I own that apartment building. So I'm not a renter, just
Okay.
for clarification. I'm here today because the chain dogs of Indian River County have no voice. There were going to be dogs shown on the monitor, but that's okay. The dogs in Indian River County are held captive in housing, the particular dogs that each of you has a packet. Those dogs are held captive in housing behind the hospital. Law enforcement in Indian River County has confirmed that there are many other chain dogs in the county and that they are often used to guard drug houses and other illicit enterprises. These dogs pose a threat to the public and law enforcement because their isolation, lack of exercise, fear, and frustration at their cruel plight breeds aggression. Indian River County does currently have tethering restrictions under the Cruelty to Animals Ordinance, but these restrictions are vague, contradictory, and do not go far enough. Comprehensive anti-dog chaining ordinances have passed in many municipalities, including Palm Beach and Seminole counties. In fact, Chief Stone, the Director of Emergency Services for Indian River County, helped draft the ordinance for Seminole County. The Seminole County ordinance is well-written and concise and would serve as an excellent model for Indian River County. I've attached in your packet a copy of the Indian River ordinance with my notes. In the beginning, it states that it's illegal to impound or confine any animal. As you go further down, it allows the chaining of animals, not for more than 10 hours a day. It doesn't distinguish between the heat of the sun or the cool evening. And then it seems to allow chaining during a natural disaster if the chain is 10 feet or longer, which I could be reading this wrong. I'm not an attorney. I think I'm one sometimes, but I'm not. The other thing is there are, in Section D, there are exceptions to tethering prohibitions, meaning an animal may be exclusively restrained by tether if the following criteria is met, and then it lists 7 criteria. So to me, it seems as if it's saying, yeah, don't chain the animal, except under these conditions, you can chain an animal 24 hours a day, 7 days a week. The Seminole County ordinance, which I've also attached, is very clear. No chaining between 9 a.m. and 5 p.m., not for more than an hour. The owner must supervise for the duration of the time of restraint. On the second page of Seminole County, it says, to sum it up, absolutely no chaining during severe weather. The Humane Society of Vero Beach also supports changing this ordinance, and a representative of the Humane Society, Ilka Daniels, joins me today to express support for this issue. In closing, these dogs endure a life on a 6-foot chain, 24 hours a day, 7 days a week. In the teeth of sweltering heat, rain, and cold, they roam a circle no bigger than what their chain allows, the ground under them trampled by their constant pacing. They are forced to sleep in their own waste, and their dead eyes reflect a life of pain, cruelty, and neglect. I respectfully request that you vote to adopt the Seminole County Anti-Tethering Ordinance. Thank you.
Thank you. Commissioners, any questions? Yeah, I'm going to go ahead and, if we don't have any questions for the speaker, I'm going to. So Commissioner Slaughter will go ahead and let you address your item.
Yes, Mr. Chairman. I would like the board to consider a revised ordinance to our anti-tethering ordinance. This revised ordinance would include most of the points from the Seminole County ordinance. We would also consider adopting some of the suggestions in the email from Chief Tewksbury of Fellsmere that was sent to me on Wednesday, August 29th. As the Attorney's Office goes through this, I'd ask them if they could reach out to the Humane Society and our own health department to make sure that they, in case there are any other humane elements that we might have missed, or if they know of any operational problems which might interfere with a proper execution of a new ordinance. But the idea being to enhance the welfare of any animals that are left outside and to make sure that they're all treated in a humane manner. If you look at even the picture, things you might not think about driving fast, the picture that Ms. Beggins provided, I'll hold it up, I don't know if anybody else would see it, but there were probably buckets there that were intended to be water buckets, but they can be tipped over, which is one of the suggestions from Chief Tewksbury to make sure that water supply can't be tipped over. But if you put these animals out for just a day, or excuse me, just an hour in the hot sun, you're going to get problems. And this is, quite honestly, one of the things I hadn't thought about at all until Ms. Beggins came forward, and I thank her for that. And one of the things I've learned from this, and I've heard it from multiple sources, is that if you leave dogs out like this, tethered like this, they actually over time become more aggressive. So they become more aggressive and more dangerous to anybody who might approach them. So with that, I'm going to move that we adopt a new ordinance as described.
Second with discussion.
We have a motion from Commissioner Slurry, second by Commissioner Flesher. Commissioner Flesher.
Mr. Chairman, thank you. And again, I want to thank you for this presentation, for awareness and all the background in moving this forward. Commissioner Solari, thank you. This is long overdue. This occurs in communities that are somewhat removed from the main street of our communities. And this is done, and I can recall back at times when I was driving a white marked vehicle and working close with animal control, I was compelled to have a bolt cutter in my vehicle. And it was used. There were times where I worked with, I believe it was Jeff West in animal control, that the chains were actually fused to the neck.
Yeah, embedded.
And embedded.
Yes.
And they're very difficult to work with. But unfortunately, these are out-of-the-way locations and so removed from public view, and it is something that's done to temper the animal as well, not just for protective purposes. And if it was for protective purposes, then people can go ahead and apply for a fence permit and get a fence so that they can protect their pet if these animals are considered pets, most of which are not. They're there for a whole different purpose and reason. So thank you again for stepping forward for the health, safety, and welfare of our canine friends.
Thank you. Commissioner Adams?
Yes, a couple comments. I am also very supportive of doing what we can to protect our animal friends, but I do have a couple comments to make. The picture that's provided, if we read our current ordinance, all the issues that have been pointed out as being a problem with this picture would be addressed. So our current ordinance says that the following are cruelty to animal violations that require mandatory court appearances. Those include confining any animal in any place or place of protection from the elements without water at all times and sufficient food. It also requires mandatory court appearance for any insufficient protection from the elements or failing to provide protection from the elements.
Yes.
So in this situation, if our current ordinance was enforced, then those two issues not being met would require a mandatory court appearance.
With that,
The ordinance goes on to say that while it might not require a mandatory court appearance, it is a violation under this ordinance to restrain an animal by means of a choker or training collar that is less than 10 feet in length for more than 10 consecutive hours in any one 24-hour period. And also, it is also a violation to restrain an unattended animal by a tether that is less than 10 feet during any natural disaster, including but not limited to fires, hurricanes, and tornadoes. So if they were restrained during a natural disaster, one of those things, that would be a violation, which is one of the things you were concerned about. It also lays out the elements that must be in place to allow tethering. And that would require a 10-foot tether, which it doesn't appear either one of these dogs have, with a swivel at both ends. It also requires that 10-foot tether to be attached to a pulley or trolley that's mounted on a cable that's also more than 10 feet in length, which it doesn't appear these dogs are. It also requires that that pulley or trolley be mounted at least 4 feet and no more than 7 above the ground so that the dogs can move back and forth without becoming entangled, and it doesn't appear that that element is met in this picture. That tethering must also not allow the animal to leave the owner's property, not weigh more than 1/8 of the animal's body weight, so it's not unduly restrictive and heavy. And it must be attached to a properly fitted collar or harness that is not a choke collar. So if the ordinance that we have currently was enforced, that would address the issues represented in this picture and the issues that you have raised that you're concerned about, which I agree with. My concern is if we're not enforcing the ordinance that we have, why would we want to put in place a more restrictive ordinance when we could simply enforce what we already have in place and address a lot of the issues? I'm also a little bit concerned that the only 2 agencies that were asked for input on this is the City of Fellsmere and the Sheriff's Department. I would assume if this is an overriding county concern that the City of Vero Beach and the City of Sebastian should have also been asked, as well as Indian River Shores, for input. And I know it's being characterized as a crime problem, and it just concerns me that perhaps we are targeting certain areas. And the last thing I want to say is not everyone can afford a fence, and not everybody is able to put up a fence if they're a rentor. So for those that work outside the home and may have an 8-hour workday with an hour travel there and an hour travel back, to be able to tether your dog in a responsible manner instead of keeping them penned up inside for those 10 hours that you may be away from home, with cover and water and food available, seems to me a very reasonable situation. And if we would simply have animal control enforce the rules that we already have written, it would address a lot of the concerns that I'm hearing from the board.
A couple comments on that one. Yeah. One is I'll take the responsibility for not going to the City of Vero Beach and Sebastian. Basically, as this came up, I was at a Taxpayers Association meeting shortly after I started working on this, and I saw Chief Touchberry, so I gave him a card and asked him about it, and I saw Major Flowers and gave him a card just to reach out and get more. And I talked to Officer Floyd about it, just meeting. So it wasn't that I was trying to exclude or include anybody, it was just I went opportunistically when I saw people. But that is why, when I made the motion, I tried to be as inclusive as possible by asking that the Sheriff's Office get in touch with the Humane Society and get in touch with our health department and others who might be concerned about this to make sure that we did it the right way. So there's no intent to focus on any one area whatsoever. It was simply to actually be inclusive and ask people about that. So that was that portion of it. And the ordinance from the county, I was unaware of until yesterday, so I didn't go through it in exact detail. But as I read it quickly yesterday, it said that, yes, you can't have the dogs without water at all times. But if you look at the picture, there's buckets, which there may be water in one. One of the buckets is turned over, so it's somewhat subjective, our ordinance. And I found that, I think that you could be too argumentative on different points, especially something like shelter and the fixed water. So I think that a lot of the points that are brought up in both the Seminole ordinance and by Chief Touchberry just sort of add and may give it a little definition. But at the end of the day, I'd hope it is discussed with the Humane Society and others to get their experience and their knowledge, so at the end of the day, we can have a more humane and more enforceable ordinance in the books. So that was my thinking on it.
May I respond?
Yes, please.
I appreciate your input, Commissioner Adams. I just wanted to point out, if you look at item B1, it specifically states, you may not impound or confine any animal in any place or place of protection without water at all times, sufficient food, and then the rest. When you go down to C5, it then says, well, for 10 hours in any 24-hour period, you're allowed to chain the dog. And then when you read, this is the one that really gets me, and this is why I feel this isn't clear. To restrain an unattended animal by means of a choker training collar or tether that is 10 feet or less in length during a natural disaster. So if I put a dog not in a choker training collar on a tether that is longer than 10 feet, according to this, I'm allowed to chain him during a natural disaster.
That's not what it says.
It is what it says.
No, it's item 6 under C, it's C6. So you have to read C first, which says the following are cruelty to animal violations under this chapter that do not require mandatory court appearances except as otherwise set forth herein for any person. Then you go down to 6, and it says to restrain an unattended animal by means of a choke, training collar, or tether that is 10 feet or less in length during any natural disaster, included but not limited to fires, hurricanes, and tornadoes. So that is a violation of this ordinance.
Only if it's a choker collar and it's 10 feet
No.
or less. Yes, that's specifically what it says.
Dylan.
The literal reading of this.
If I could, Bill DeBrawl on behalf of the County Attorney's Office. There are two types of citations that are issued by animal control. One citation is for a non-mandatory court appearance, kind of like a parking ticket. You just pay the fine and go on your way. The other type of cruelty to animal is a mandatory court appearance, where you are issued a summons and you must go to court to answer the violation. That's what they're talking about in this case. The first paragraph excludes these two types of instances of cruelty to animals from mandatory court appearances. That's all that they are doing.
But it is still considered cruelty to animal and a
Correct.
violation.
It is still considered cruelty to animals. And if there would, and our ordinance says prior to this, if this would be a second offense, it would then be bumped up to a mandatory court appearance where they would have to come in and answer to the court as far as their second and subsequent violations of the tethering ordinance.
But if they come in and say, during the hurricane, my dog was not on a choker training collar and the tether was longer than 10 feet, they're allowed to do that. That's what this says.
But then you still have an issue, though, ma'am, about whether it's cruelty to animals and whether during you were insufficiently protecting your animals during a storm.
Okay.
So you still have that issue.
Okay.
So where I would be on this is I'm fine bringing it back for more discussion and fine tune it. I understand your point. It does seem confusing.
Yes.
If it is a 12-foot tether, it's technically not violating number 6. And then under B, the ones that require court appearance, it really doesn't specifically address rain, fire, tornadoes, et cetera, et cetera. So I can understand where there's some confusion, and we probably do want to bring that back and clean it up. So I'm fine with that. I do agree with Commissioner Adams. I think we need to consider that there are some working families with both folks have to work, so I'm not really in favor of the 1 hour thing. I will say this, when my family lived in Narcoossee, we got a black lab collie mix, and he spent a lot of his first year on a tether out in the front yard, which was good because my wife at the time was a stay-at-home mom and the kids played in the street, so there was a lot of activity there and it was fine. When we moved here to Vero, he preferred being on a chain in the garage out front than roaming free in the backyard in a fenced backyard. We put him in the backyard and we were leaving, he would whine and cry and bark. When we put him out front on his chain, he was happy as can be. Now I realize that breeds are different and we made sure there was water and If there's elements, he could go in, the garage door was, left open, so he could come in and out, but he could also get to the grass area and the tree. So I think we can fine tune our ordinance to make sure that those type of things, shelter, water, protection, that can all be accomplished and just kind of clear up some of this confusion. So, but I do think there's a lot of people that responsibly take care of their pets, and I want to make sure we don't eliminate what they're doing by maybe, pushing this too restrictive. But I'm certainly in favor of working with the community and the agencies and everybody to fine tune what we have to make sure we're protective of the pets. And there's some confusion that we're going to agree with you that you could read it that way and be confused. So, but I'm certainly glad that I'll support the motion now to bring it back for more fine tuning, and we'll go from there.
Can I say one more thing, and I'll be done?
Oh no, that's fine.
You guys anymore. Section D, first 4 words, exceptions to tether prohibitions? Whatever. Anyway, an animal may be exclusively restrained by tether, provided such tethering system meets all the requirements. It doesn't say how long. So basically, you're saying don't do it, and then Section D says, well, you can do it under these conditions. So which is it? That's why I'm saying this is contradictory and it's not clear.
Each of these sections have to be read in the context of the entirety of the ordinance. They are not exclusive of the rest of the ordinance as written.
And it shouldn't say exceptions to the tether ordinance. It shouldn't say that, because it basically makes everything else null. It's done. Now, the reason I'm pushing for the Seminole County is there's none of this confusion. It's clear. It's basically saying a lot of the same things. But when these animal control officers go out, if I can't figure this out, and I've studied it, and I did this in Palm Beach County, I mean, I'm very well versed in this issue. These guys need something clear that they can say, listen, this is it. Seminole County's great. This ordinance is clear, nice, succinct. I'm just asking you to consider it.
Do we know how many citations have been issued under our current ordinance?
Probably 0.
I know Chief Stone is here. I don't know if he has an answer or not, but okay.
It's not enforced.
Well, that's the problem.
Mr. Chairman?
Oh, one of the reasons why it's not enforced
Commissioner
is
Fletcher.
it's vague.
In your example there, and I'm not suggesting anything to do with breed preference or designation, but could I ask what type of dog was that? That was a family pet?
It was a black lab collie mix.
Black lab collie, nice, family oriented.
And I agree. There
This is
might be
all
other
about
breeds that would react.
I mean, these tend to be of a
Square-headed
pit bull, aggressive type of dog that's being geared to be a little bit more aggressive and not being respected and left out in the heat, and they're toughened up by the chaining. I think that's, I appreciate the example, but I think the example that we're trying to cite is that if you go to the outer bowels of the community, you might find, and I mean that in a kind way, whether it's north, south, east, or west, maybe not so much on the beach side, but there are rural areas that you find this occurring more frequently than not for protective services and training purposes, and I believe that we need to address it. Thank you.
Ilka, did you want to speak? Come on up.
Hi. My name's Ilka Daniel. I'm the Director of Animal Protection for the Humane Society of Vero Beach and Indian River County. And I am here today on behalf of our Board of Directors and our membership. And we do support the Seminole County ordinance for the simple fact that some of the tethering that is occurring in the county currently is inhumane. And it's very, very difficult to answer your question, Susan, about the ordinance being enforced that's currently in place. It is. We do get dogs into the shelter fairly regularly that are being brought in because they've been confiscated due to inhumane conditions. The problems that we face in Indian River County is Nationally, the suggested ratio of animal control officers to county population is roughly 1 humane officer to 15 to 20,000 residents. We have roughly 1 humane officer to 35 to 40,000 residents currently in Indian River County. And the way the current ordinance is written, where it talks about, no more than 10 hours a day or things like that, it's very, very difficult for our officers to enforce that, where in the Seminole County ordinance, it's very specific as far as times, weather conditions. I know our sheriff's department also deals with barking dog complaints, and that's probably one of the most frustrating things for officers to face that also cause neighborhood dissension. And I think that this ordinance, especially if we can put together a team to look at it, I think we can fine-tune those things to reduce calls for service. And industry data shows us that dogs that are chained are actually 2.8 times more likely to exhibit aggressive behavior. And I'm not quite sure if Tad has the numbers, but I know we're looking at it's somewhere between 250 to 350 animal bites in our community annually, and the cost that goes to the taxpayer sometimes for that, especially where rabies prophylaxis is required. So, I mean, there are a number of things that I think we can do that this ordinance would help as far as reducing inhumane conditions, reducing our bite cases, reducing impoundments eventually to the shelter. Whether we do some type of a moratorium where we allow people to put up a kennel run rather than fencing off, their property if they have a dog that they're not able to tether safely. Because we do unfortunately deal with strangulations and deaths and dehydration. We deal with neighborhood complaints where people are tormenting chain dogs because they are a bully breed or they've got a square head and they're being tormented. It's not fair to the dogs, it's not fair to the owners, and it's not fair to the neighbors to live in fear of a dog like that breaking loose. So I think reviewing it would be very, very positive to see what we can do as far as making it better for the animals themselves as far as being treated inhumanely, and for the public to restrain their dogs safely and to reduce calls for service and impoundments. So I thank you very much. Any questions?
No? Any questions?
But you would suggest that most of the dogs that have been rescued were not beagles and poodles?
Correct. And unfortunately, I have come across the Humane Society is a court-appointed agency. We also do handle animal cruelty. I have come across those cases where dogs have been impounded in dog houses where the floor of the dog house is used to hide both illegal weapons and narcotics. And so I think in fine-tuning our ordinance and looking at specifics such as, timelines, specific timelines, 9 to 5, the heat index fabric of the ordinance is tremendous because unfortunately we do get a lot of dogs that are brought in where it's too late. They have suffered heat stroke because they've been confined improperly. And I think this would give a tool both to law enforcement and to animal control to make it a little bit easier on them to do their job. Not so much, Susan, that they would be going door to door, but that it would be a tool in their tool belt to use rather than have to go through an investigative process to look at, has the dog been out more times than not?
Well, again, everything that you've mentioned that's a problem and why you're picking up and impounding dogs is because they're tethered incorrectly. And our ordinance speaks quite a lot to what is a correct tethering method. And if you're picking them up, then that means that that this ordinance is not being followed. So I don't see why we need to go beyond that. And again, to the issue of 9 to 5, that is restrictive to working families.
It is.
And that would be a problem for me. I mean, I have no problem clearing up the language related to natural disasters. But again, mentioning the dehydration, our ordinance speaks to that. Commissioner Solari, if you feel it needs to be added that water source is not able to be tipped over, I have no problem with that. But I think we are looking for a problem where the real problem is the lack of the ability to enforce versus what the ordinance says as written. And that is a different issue than changing the ordinance. But what is being presented to us today is changing the ordinance. And the last thing I will say on this, I promise, is I do find it very offensive that we keep talking about the far reaches of the community and the crime issue and specific species. If that's really what we're trying to address, then that's a whole different ordinance. And the issue of crime is not the issue. That is a different issue to be addressed than animal cruelty. If we want to talk about animal cruelty and the treatment of animals, then let's talk about that. But let's not mischaracterize the fact that there are people in very affluent neighborhoods, the people within the city of Sebastian, people within the city of Vero Beach, people on the Barrier Island that are inappropriately treating animals. And to continue to say that it is in crime-ridden, drug-infested neighborhoods, I find offensive.
Well, you've never driven in a patrol car and had to respond to an emergent circumstance.
I'm not going to argue with
Find
you about it. I
yourself
just
in
said what I said, and that is how I
a community
feel.
that is not
And you can
well-traveled.
continue to say
That's
what
all
you
that
want to
meant.
say.
Well, then,
Thank you.
unfortunately.
Okay, hang on, let's kind of calm down here a little bit. Commissioner Slaughter, your motion is just to bring the ordinance back and try to fine tune it and clear up a few things and.
Yeah, but I do want to say, I mean, I don't know enough about dogs or anything else to say that one species or another is bad, to say one location or another is bad, to say any of the things that Commissioner Adams just said that my actions were basically pointed at. To me, it was simply a matter of inhumanity. Dogs are treated wrongly sometimes, and this, I thought, was actually as gentle the course of arm of the state as you could apply. This isn't something like, if you really want to treat things right, I mean, when you have a state that you have to get training and a license to do someone's hair, then you dang ought to have 6 months of training and a license to get a dog, which so many people then treat inhumanely. But again, I don't like to use the course of arm of the state too often. This was something which I thought could be applied more easily by those people who have to go out and enforce it every day, and was basically aimed at making sure that these animals, that the few that are to be abused are treated somewhat better. That's all. And that's where I hope that we go today.
So, again, Commissioner Slaughter, your motion is just to work with staff, various municipalities, various agencies, and look at our ordinance and try to fine tune it, to tighten it up, and make it more so that we're protecting the animals.
To look at our ordinance, the Seminole ordinance, Chief Touchberry's comments, any other comments that come along in it, and to try to craft an ordinance which will be more humane to all animals in Indian River County.
Very good. So for the clerk, this is under item 14B1. We have a motion from Commissioner Slaughter, second by Commissioner Flesher. Is there any further discussion on the board? Anyone else from the public that wishes to speak to the motion? Seeing none, all in favor signify with aye. Aye. Any opposed? That motion carries 5-0. Ilka and Mrs. Beggins, thank you for bringing this up. I'm sure probably Commissioner Slaughter will keep you posted if this comes back on the agenda so you can participate again.
Thank you very much for your time.
Thank you, Ilka. And with that, we're going to take a 10-minute break. We'll come back at 10:37.
Make sure you check with Downtown Bureau, because there's a lot of
Go ahead and call the meeting back to order. Next up is request to speak from Evan Esposito, but I do not see him in the audience. So we'll go ahead and move on to item 3, a request to speak from Fred Menzing regarding all aboard Florida / Brightline / Florida East Coast Railway railroad crossings, tunnels, and bridges. Good morning and welcome, Mr. Menzing.
Commissioners and citizens, I am here having been listened to with a deaf ear in the past, and I'm going to start by saying, fear not Brightline, fear the freight train. Whether you read between the lines, closely disguised when the Florida East Coast Industries was acquired by a Mexican railroad company, it was their announced intention to get a rail link from the East Coast container ports of Florida to Mexico. The rail link from San Diego, Florida to Mexico had nothing but problems. Containers disappeared for 3 months, turned up in New York, Chicago, and Denver, and never getting to Mexico. We have a situation at hand. The CSX company, which owns the connecting link from Jacksonville, Florida, across the Panhandle to Alabama, is for sale. The information that I have been able to gather, it could be sold without us even knowing to whom or why, without public hearings, or it could become a very public event. It's obvious that the Mexicans are interested in having control of that piece of track, which is about 350 miles, which would double the amount of track they have control of in Florida. We have a situation at hand now that a couple of times a week we have a container train that comes through Vero Beach at night. At times it is 2 miles long. It will not be any longer than that because of the layout of the freight yards in Miami. Those containers are on their way to Mexico. Because of that, you have an equal train coming back with containers to go to the Port of Miami. The state of Florida backed the development and enlargement of the Port of Miami for containers to be able to handle the largest container ships in the world. So we are stuck with a railroad that's going to be hauling containers. Now, what concerns me is this business is expanding worldwide. We are going to get suffered with this expansion. The FEC is in a process, whether it's for Brightline or if that's a disguise, I don't know. I do not work for the FEC or any of these other organizations, but they are geared up to double track the entire railroad back the way it was in the 1960s. We are going to have a problem in this county. We have a bridge across the Sebastian River that has to be replaced in the next 10 years. We have a curve in Brevard County approaching the bridge, which is a speed restriction point. It's not going to go away. What happens? We have a major accident on I-95 at the Fellsmere exit. We have a double-track railroad. We have the coincidence that might happen once or twice a year of a 2-mile freight train northbound at Roseland Road. As the last cars cross Roseland Road, a southbound of the same length crosses Roseland Road. Because of speed restrictions, they're going to be running at about 30 miles an hour, assuming there's no other restrictions to go slower. At 30 miles an hour, the first train is going to tie the crossing up for 5 minutes, the second one for 4 more. I'm sitting in an ambulance. The trauma people at the hospital are waiting for me, and you can't get me across the tracks because we have 2 trains there at the same time blocking the road. We had this problem through New Jersey when the Metroliner started in the 60s. Between Newark, New Jersey and Trenton, New Jersey, there is not a single grade crossing on the route the Metroliner ran on. When it started, the news, at least 2 or 3 nights a week, a car got hit by the Metroliners. The Metroliners brought in certain additional safety factors. A locomotive runs with a headlight. The headlight is center and high. It runs with two lights down low. On the railroad, they commonly call them ditch lights. When they are blinking, you are 1 minute or less from being hit. When they are steady, you're out on the main line. You're not in risk at a grade crossing. People that run grade crossings have to be put in the class of being idiots. Sorry if it offends anybody, but that's how I feel. I had the misfortune with 3 coaches of elementary school children being pulled by a steam engine in 1967 of hitting a tractor-trailer load of turkeys. The driver was so spaced out that he was 2 days before he knew he'd been in an accident. Fortunately, no one was injured. But believe me, you know, that gave me an opinion about people who run grade crossings. They should be tied to the tracks and run over. Now, I am asking that you take and instead of continuing to spend money on something you're not stopping, you've spent $3 million, you haven't stopped the train, you've delayed it, period. I don't see any way that you're going to stop it. It's time that you decide to befriend it. You've been excluded from being invited to discuss having a station in Indian River County because of your litigations.
Actually, Mr. Mensing, the city of Vero Beach was invited.
I said you, Indian River County.
I think the location would be in Vero Beach, and that's who they extended the offer to.
Whether it's Vero Beach or Sebastian or what, you know, I'm not, you know, into discussing at this point. I feel that it is time that you made a serious study, at least 2 places in this county, to get a year-round train, don't count, crossings of the railroad for emergency vehicles, medical cases, so that no one is denied 2 or 3 minutes or 10 minutes of medical care because of a train. How you pay for it is something you're going to have to investigate. The towns and townships and counties in New Jersey all found funding, and this is in the days when the Penn Central was bankrupt, the principle behind that, you know, but it got done. You know, we need to be doing it here, now, not next week or next month when we have another, you know, buildings built that are going to, you know, cause an issue of doing this. And I'm not saying you do it at Roseland Road or Main Street Sebastian or, you know, here in Vero Beach. You know, I'm not saying where it, maybe it should be a whole new crossing. That's what they did in several places in New Jersey. Left the railroad grade crossings, you know, and closed them and put whole new roads in. But it is time that the planning people of Indian River County accepted the fact you're not going to get all aboard Florida moved off the Florida East Coast right away. The Florida East Coast tore up the Kissimmee Valley line in 1942, and it went from Okeechobee through Yeehaw Junction and Holapaw to Palatka, you know, because they couldn't make any money out there. They're here. They made Indian River County. They made all the counties. If they weren't here, you know, I don't know what we would be, how we'd be living. But I'm, you know, really asking that you look hard at this and realize that the railroad will be double-tracked on the existing Sebastian River Bridge before it's ever replaced. Its replacement is going to be a construction project where they're going to have to maintain half the bridge and build a new one and then tear it down and build the new one there, as they did with the Route 1 bridge. And something else that we should be looking at, when the new Route 1 bridge was built, it was raised considerably for marine traffic. Without raising the tracks, we could get another 6 or 7 feet of clearance if the railroad was encouraged to use a Warren Truss type bridge instead of the deep 56-inch I-beams that are under the existing bridge for boat traffic, and it would increase the interest in people having boats up the Sebastian River. Now, you know, what it's going to take to get you to realize that our health, welfare, and safety depends on getting over or under the railroad. Basically, if you go to a bridge, it's going to have to be 24 feet above the track at the bottom of the bridge. So that bridge is going to easily reach 30 feet high, and you're going to have to span 100 feet because the railroad's not going to let you put bridge piers in there right away. If you tunnel under, you're only going to have to get down to the bottom of 20 feet. And the distance of the approaches with a bridge is going to be at least 1,000 feet of approaches each way to the bridge if you do a 3%, which is a steep grade. If you do it with a tunnel, each approach would only be 700 feet long. And the tunnel can be constructed in such a way that except in an extreme hurricane, it's not going to flood, and the fact it's in the water table doesn't matter. There's tunnels under the Hudson River for over 100 years with trains running through them that are, you know, under the water. And I'm asking that you take and seriously consider looking at how to do it and then figure out how to get it paid for. I'm not here to say that the county should pay for it, the state should pay for it, the federal government, the railroad, but it needs to be done for the sake of medical emergencies and fire apparatus. Thank you.
Thank you, Mr. Mensing. Moving on now to public notice items. Mr. Reingold, if you would do the honors, please.
Thank you very much. We have a public notice of a public hearing scheduled for October 2nd, 2018. It is to consider adoption of a notice of intent to affirm the existence of a recreational customer use of the beach on private property. The item will be legislative in nature, and again, that'll be a public hearing on October 2nd, 2018. And with that, I turn it back over to the chair.
Thank you. We now move to the county administrator matters, the agreement for sale and purchase of Dodgertown Golf Course property. Mr. Brown.
Yes, thank you, Mr. Chair. What we have before you today is a proposed contract for purchase and sale of the Dodgertown Golf Course property from the city of Vero. Per direction from this board last week, county staff has worked with city staff on a proposed agreement with the city to purchase Dodgertown for the $2.4 million that has been discussed. We've gone back and forth with city staff, have agreed to the terms of an agreement, and that is here before you for your review. We want to get this, the basic thought is we want to make sure that we have a contract and all of the documents prepared for the city of Vero for us to present to them at their October 2nd meeting. Hoping not to schedule a special call meeting, want to make sure that we get this agreement approved by the board. We can send that along with other supporting documentation to the city. We would plan to submit some of our basic outlines that we've provided to you as far as development of the site. We have some very preliminary draft conceptual plans. We have 2 of them here that we can look at. Those are just very preliminary. I would say at this time they kind of give an idea of a couple of the different things that could happen there. I would say a caveat is that we still need to discuss the plans for that property with Major League Baseball, so nothing would be set until that's done. I also say we've met, county staff has met with some of the folks from the Historical Society, Ruth Stambridge, Amelie Loy, Fred Augustin last week, and they have various different ideas, and I think one of the things that I want to emphasize is we have some visual aids to talk about the things that could happen there, but I don't think we need to finalize anything right now. I think we have the ability to be flexible to hear. I think we heard some really great ideas last week about some things that could happen at that location. So we want to be able to continue to explore those. I don't want to foreclose any options, but our basic premise and our guiding light is going to be that everything that we do there, we want it to be not just compatible with historic Dodgertown, but complementary to historic Dodgertown. And we also want to make sure that we are honoring the history of what has been there, what has come before. So those are basically the terms. We can get into the conceptual plans if you want to a little bit later, but first I'd like to pass it off to Bill DeBraw, who's got a little more detail on the terms of the agreement.
Thank you, Jason. Good morning, Bill. Welcome again.
Thank you. Bill DeBraw on behalf of the County Attorney's Office. Just a couple of quick slides as far as the terms of the purchase agreement. As Jason said, the purchase price is $2.4 million. Upon approval by both the city and the county would have to deposit $50,000 with an escrow agent, title insurance company, as deposit for the purchase. And we would be in control of which company we use. The permitted exceptions that we discussed, first and foremost, deed restriction, no residential development. The existing City of Vero Beach utilities would remain. They're on site where they are. The runway protection zone and the navigation easements would also remain. And the city has asked for a 800 square foot corner clip right at Aviation and 43rd as far as right-of-way for the planned expansion to Aviation Boulevard.
And Bill, that clip is in the runway protection zone, isn't it?
Correct.
So the runway protection zone just says no permanent structure, right? So giving that up for right-of-way is...
I've discussed it with Mr. Spierka. He has no objection to anything.
Okay, thank you.
As far as costs to the county, we would have to pay dock stamps. That would be estimated about $16,800. We'd have title insurance costs, appraisal fees, and the Phase 1 environmental fee study cost. Timeline. October 5th is the deadline for approval by both the city and the county. November 5th, 30 days later, is the effective date of the agreement, and that would be the timeline for the county, or the deadline for the county, to provide a title commitment to the city. 30 days later, on December 5th, we would have to complete the survey and environmental assessment of the property. 15 days later, on December 20th, we would have to complete the appraisals that would support the purchase price. Also on the 20th, we would have to complete the physical inspection to ensure that the property is suitable for our intended uses. Now, if any of these if at any time any of these deadlines would reveal a title flaw, chemical spill, et cetera, we would be able to back out of the deal if we so choose, get our purchase or our down payment returned, or we could go forward with the purchase and accept the property as is. The closing date is anticipated to be on or before January 20, 2019.
Bill, on the October 5th date, obviously we meet October 2nd prior to the city council meeting. Is it your intention that we approve the contract today, and then so it's ready to go if the city moves forward, or you see this coming back to us on the 2nd?
No, let's not beat the dead horse.
Right,
Here's our offer to them. Go ahead and vote it up or down.
So we'll vote this up or down today, and then if the city approves it on October 2nd, we're good to sign it and go.
That would be my recommendation, to provide the city with a signed offer for them to consider at their meeting.
Very good.
And
Yeah, and I just want to make sure that we have everything ready to the city in time for the regular agenda deadline, so the city council can get the backup and have that as part of their agenda for their October 2nd meeting.
Very good. Commissioners, any questions of Jason or Bill on this?
Jason had mentioned something of the proposed concept uses for it. Is that something on an overhead or something you can put up? And again, these are just concepts, nothing's permanent, nothing's...
We have a couple of draft conceptual plans. You're looking at the first one here, which would be what I would say probably the most intensive development. So you have the southern portion of the property would remain open green space. This would be available for your farmers markets or your food truck events and things like that, kind of an open community space. But that would also provide the parking that may be needed for the larger events at the facility. You'll see here there are some of the historic raised greens and raised tees. The plan is to kind of preserve those in this model. We have replanted some trees along the 43rd Avenue side of that that may be needed, that will likely be needed to replicate kind of the historical tree canopy that's there after 43rd Avenue was widened. There's a purple, you'll see a walking trail that provides access, that it could be a good walking trail that could be utilized by folks just on a regular day, potentially a bridge over to the new cloverleaf there, and then 2 access points to the west side of Holman Stadium. There is the potential for something like possibly a restaurant and hotel that would be complementary to the facility. And I will reiterate the caveat that you know, Major League Baseball, we haven't gotten to that point yet. We're still working on the wedding with Major League Baseball. We haven't gotten into planning the honeymoon just yet. So I want to keep that option open. They may have a desire for additional ball fields or something like that potentially. And this protects, you know, this observes the runway protection zone, provides open space, and a potential area for complementary development on the site. The next preliminary conceptual plan incorporates the stormwater, the water feature. So this, you'll see this kind of meandering river looking structure here, which would take water from the main relief canal, treat it through a system, and would travel around part of the site. Would be an attractive feature, and then it would dump into the existing stormwater tract that's just west of the ball fields, and then eventually back into the main relief canal after it's been treated. Once again, we have the walking trails. In this case, the walking trail goes along the stormwater area. There are a couple of crossings here where you've got some bridge crossings. Would be a nice walk. The same thing with maintaining the tree canopy on the west side. Also preserving those historic raised greens and tees. But you'll also see some open space that could be used for parking, could also be used for your festivals. We've got an internal roadway. This option would not allow for enough space for a more intensive development like the restaurant type thing. About the only thing we could contemplate is potentially a conversion of the in this scenario, a conversion of the existing clubhouse into maybe a museum type structure. We may be able to get some grants with that. We've talked to the Historical Society about doing something with that. I will point out that's in the runway protection zone, so we haven't researched what our ability to develop that is with the runway protection zone there. There already is a building there, but we've obviously got to make sure that we're in compliance with that. And the open green space shifts to the north, provides the parking, still would have that open green space for your public festivals and things like that. So similar walkway with bridge over to the cloverleaf, and just kind of a nice public space for folks to use. We'll reiterate here, these are preliminary in nature. We did talk to the Historical Society, Fred Augenstein, last week. There are some really interesting ideas. I think there's a lot of potential there on that site. I don't want to foreclose any of those options at this point, so this is kind of a visual aid. If anything, welcome any comments from the board. Any proposed changes would like to have a deliverable to the city that kind of outlines some of these types of things that could happen there. So with that, I'll stop talking and am available for any questions.
Any questions? I just, again, want to make sure we reiterate these are just conceptual, and that I think one of the biggest points, or two big points of this, is that one, if the county purchases property, we are in no rush to do anything with it. There will be plenty of time for public comment and more input. And so these are just purely conceptual ideas, just for discussion and ideas, but it's a long, long way from actually doing anything there. I think the other critical part of the contract is that deed restriction. The city council seems very supportive of the fact they don't want residential development there. And so I think with the county saying, yeah, we're great with that, we'll put the deed restriction on, and, you know, that wording will go forward. I think that's a key component with that too, so. Rich, anything for the good?
Just here for answer any questions.
Okay, very good. If there's no questions or comments from the commissioners, is there anyone from the public that wishes to speak on this item? Mr. Johnson, come on up. Welcome.
Bob Johnson, Carl Wynn subdivision. I apologize, I missed the public hearing on the purchase. I was just wondering where the $2.4 million was coming from.
So we've identified $250,000 from tourist tax and the remaining $2,150,000 from optional sales tax.
Thank you. Do we know what's going to happen to Dodger Pine area? And the city has proposed for the Dodger Pine area, which is
that is in private development.
Yeah, that was sold a few years to a private development company.
Is that what's going to be? We don't know then.
Yeah, the city doesn't own anything there.
Right.
And it is, I believe it is zoned for residential development. And I think it was 3 years ago maybe that a private development company, I think from the West Coast, purchased it.
Maybe it would be beneficial to know what is planned in the near future for that area over there too, because it may complement the necessity for parking or whatever. Thank you very much.
Thank you. Welcome.
Good morning. Dory
Morning.
Stein, Indian River County Chamber of Commerce. I just wanted to let you know that yesterday the Chamber Board unanimously voted to support the sale of this property from the city to the county. The primary role that the board saw as the county's intent was to make sure that this was done with an intentional master plan to continue to promote our tourism and economic development here in the county. The board also wanted to reiterate the need for transparency as you go through this process, and just to make sure that you understand that you have their support as you continue to move forward on this. I have in front of me a letter that I will pass out to you, and we will also be distributing this to the city of Vero Beach as well, so that the city and the county know what the Chamber's intentions are. We're here to help in any way we can, and we want you to use our economic development operations and our EDO abilities in anything you choose to do in this, and you have the Chamber's support moving forward. So thank you very much.
Great, thank you, Dory, we appreciate that. Thank you, Dory. Anyone else wish to speak on this?
Good afternoon, council, ladies and gentlemen. Joseph Paladin, President of Black Swan Consulting. I have several comments on the development of that property that the developer prevailed, but I'm going to hold those comments until we have the city meeting. But what I would say is this: I'm fully in supportive of the county buying this property, and I think the plans we have is most beneficial for the county and the city and the people of Indian River County. One thing I'd like to ask about our program going forward, purchasing this property, do we have any intentions or thought process in our contract that states us keeping the property no matter what we do with it? Because I know we have a lot of time to decide that, as Jason said, but we have no intentions of flipping the property or selling the property.
It is not my intention that we would ever take this parcel and separate it from the overall campus of historic Dodgertown.
And I agree, that's part of the big advantage of the county buying it, basically.
Right.
And that's one of the things I'd like to point out that I'm not going to get into detail on, but the contract that was presented by the developer is, I'm very familiar with contracts and development and entitlements. It's a flip contract. So we don't know whether he has any intentions of doing this project or not. We don't know who might wind up doing it, but the contract's clearly written purposely to be able to flip it to someone else or another developer, unknown, unheard. We don't have any idea. So that's a very important point I think the county has in going forward with the city. They know who the buyer is. We really don't know who the buyer is with our competition. So I think that's going to be an important point that we'll discuss at the city meeting. Amongst other things, you know, the county is here. They know the county will close. They know the county is capable of closing. The city has no financial package. They have no proof of funds. They have no background whatsoever on this project going forward besides us. So I think the county is in a great position, and I ask everybody to try and be there at the city meeting to try and support the county in this purchase. I think it's a good idea. Thank you very much.
Thank you, Mr. Fallon. Anyone else? Red, ready to come up? Good morning, welcome.
Thanks. Fred Augenstein. I live at 179 Caprona Street in Sebastian. I had a presentation that I was going to give at our other meeting. It's in some cellophane, so it looks a little bit different. But one of the things that I wanted to talk about just a little bit, to just give some other ideas of what could be done with the property. Leaders come to mind, facilities come to mind, organizations come to mind. This is kind of the leader on deck. This is Rob Manfred, president of Major League Baseball. And when you think about this property, you know, it means a lot of things to a lot of different people. But this gentleman, it means a lot from the standpoint of what he did becoming a professional baseball player in 1947 until he retired in 1956. Unfortunately, he didn't get a chance to play at the golf course because it wasn't built until 1965 and opened in 1966. But his legacy is something that is still a part of what should be done to be a part of what that piece of property becomes at historic Dodgertown. A life is not important except in the impact it has on other lives, one of his famous sayings. And to me, that's one of the most important items that we need to look at when we're trying to figure out what to do with this other property. And another famous thing he was known to say is, life is not a spectator sport. If you're going to spend your whole life in the grandstand just watching what goes on, in my opinion, you're wasting your life. Well, in this situation, I just had to speak up because I felt like I need to get out of the grandstand, because it's a situation where this property means so much to me, not just from the standpoint of when we moved here in 1984, but what the leaders ahead of him did for this community and this county. And this is Merrill Barber along with Walter O'Malley, Peter O'Malley, and Kay O'Malley. The plane was called KO2 at that point. They were the first set of leaders that were here, and along with Branch Rickey, who was the one who actually did the signing of Jackie Robinson in 1947 that's shown in this picture. But the situation for me is even more difficult from the standpoint of the O'Malleys really have never gotten the credit. When they did the movie 42, it was really more about Branch Rickey. The O'Malleys were kind of in the background, if at all, mentioned in what went on. And they're a family that's very modest. I'm not sure exactly when this picture was taken, because we're showing a picture that's what you say, like 1957, where this field isn't there. But there is a field that was created that was a mirror to Holman Stadium. This is dated 1953, but I don't know if that's exactly the date or not, because it talks about when the Holman Stadium was open. Because you guys have a picture from 1957 that it kind of looks like the field is not there, unless they then pushed it over and then also put trees back on it. I don't know exactly what happened. But there is a real possibility that Jackie Robinson might have played on this field on that land, or fished in the lake, one or the other. But he didn't get a chance to play on the golf course. That sometimes people don't understand, that he just wasn't there when the golf course was built. So this photo shows Holman Stadium once the golf course was in place. And you can see behind the stadium, the lake, and then there's actually a green with 3 traps around it. And that's what it looked like during that time frame after 1966. So the situation is that so many people should be heralded for what happened on this property. The gentleman in the middle of this picture is Bud Holman. He's the one who the stadium was named after. Jackie Robinson is above him there. And that's Jackie and Pee Wee Reese at historic Dodgertown, turning a double play in practice. Again, Jackie and Pee Wee Reese, which, you know, in the movie 42, everybody got to understand about what Pee Wee meant to that whole situation with Jackie as he went through his trials and tribulations as the first black player in professional baseball. Here he is again with Roy Campanella, who was a great catcher. This next photo I'll show you is when they were doing some of the roads around Dodgertown and naming them. They're getting ready to do Vin Scully Way. They had already done Duke Snyder. And you'll see Roy Campanella in the wheelchair because he was in a terrible accident. So he was the rest of the time with the Dodgers, he really was a consultant, even though he never got to play again. Here again, the disconnecting facilities with leaders. That's, again, Peter and Don Drysdale, Duke Snyder, and Sandy Koufax, who still lives in this area. The other thing that sometimes we don't think about, because we always think of the Dodgers, there's a lot of other great players that played here. That's Hank Aaron at the plate at Holman Stadium. There were great players that were from other teams that played here, and sometimes we forget that. Another great player, when you consider standing by Sandy Koufax, is Nolan Ryan. And that's on Dodgertown property. I guess the point that I'm also trying to make when I show you a few of the more modern Dodgers that were here is if we have Major League Baseball in control of this park, it's a different facility. They have the wherewithal of all the teams of Major League Baseball. It's not the same thing as having a team there. And when we consider all the ones we remember, there's a lot of different opportunities for us that wouldn't exist without Major League Baseball's involvement. And the other key ingredient to me is I hope everybody got a chance to read Ray McNulty's article in 32963 this past Thursday. Because Peter pretty much laid out the situation that he needs somebody to take over for him, or this whole Dodgertown, historic Dodgertown, could be completely gone. And then it doesn't matter if you try to build a hotel because there's not going to be anybody wanting to get into those hotels, and not even the ones that are being built already, if you don't have historic Dodgertown still there. And to me, that's the key ingredient to all of this. The other situation I'll talk about is just that relationships build over time and they continue to go. This is Jackie Robinson with Martin Luther King Jr. And that's Jackie Robinson with his son at Martin Luther King Jr.'s famous speech, the I Have a Dream speech. I put that up there because that was about the time when Holman Stadium was being built, a little after that. And then we get to the point where, in honor of him, on April 15th every year, every player in the Major League Baseball wears number 42. This happens to be the St. Louis Cardinals. This happens to be the Detroit Tigers. This next slide is in Los Angeles, where they just dedicated a statue recently to Jackie Robinson out front. The same thing happens in our community on April 15th. We just had the 5th annual Jackie Robinson celebration game. And although it doesn't get quite the same notoriety as every other ballpark does, if Major League Baseball takes over, it'll take on a different meaning in my mind. It will be a situation where this is where a lot of history took place in Jackie's life. There's a lot of history that took place in Vin Scully's life, probably more than any place in the whole country. Vin Scully spent almost 60 years being the announcer for the Dodgers in our community. Now, he was in Boston, he was in Brooklyn, he was in LA, but he probably spent more time here as the announcer of the Dodgers than he did anywhere else. The other thing that's important is we need to herald the people that were here and all the time worked on this property. Craig Callan, who actually came out of retirement again to try to help this deal happen with Major League Baseball. Pat O'Connor, the president of Minor League Baseball, who was another one of the leaders who actually helped it not be developed in the first place. That's Liam, that's Craig's son. And it took a lot of coaxing, but we did get Craig to throw out the first pitch at the 5th annual Jackie Robinson celebration game, and actually Pat was catching for him, and Pat was the one that got him to do that. Pat O'Connor's been at most of our Jackie Robinson celebration games. He's president and CEO of minor league baseball. He also happens to be a classmate of mine. He went to the same high school in Central Ohio as I did. He was a year behind me. So I know Pat really well. And we've spent some time at Historic Dodgertown on a variety of different times. It's a situation where those relationships continue to flourish over the years. And he is very appreciative of what we've been able to do with the crowds at the Jackie Robinson celebration game. And here we get to another point from the standpoint of the parking situation that is also talked about a lot. This is just one of the Jackie Robinson celebration games. You can see in the distance that cars are already parked on the historic Dodgertown golf course. Because especially if we get to a point where Major League Baseball considers the fact of maybe having Major League Baseball teams come and play spring training games there. It won't be a team there, but it'll be Major League spring training games. It'll have more of a population at this park than a minor league game would be, even if it's just once a year. So we do have to consider the parking aspects and what happens with that. I mean, the other aspect I talked about before is our sons would have never gone where they did if they hadn't been exposed to historic Dodgertown. I owe a deep debt of gratitude to the O'Malley family. I've never even actually met Peter O'Malley. I sent him a letter. He sent me a nice note back. He knows that I've been involved in the property, but I just have a deep sense that I need to give back to the property, and that hopefully the city of Vero Beach will understand how important it is because of the effect that it had on us. Our oldest son played at the University of Florida. He then pitched his first major league game for the Arizona Diamondbacks against the Cincinnati Reds, which was my childhood team too. It's something that, again, would have never happened if they had not been exposed to historic Dodgertown. That's him on the scoreboard at Chase Field. The other situation you talk about with kind of relationships that happen in facilities like historic Dodgertown. The president of the Arizona Diamondbacks was Derek Hall. He was also the sports information director at historic Dodgertown. And he was there during the time that our son was there. It was something that we would cherish. That was we were there at that game, his first game that he pitched. Pitched his second game in Miami against the Marlins. He also got to pitch at Wrigley Field later that year out of the bullpen. And there is a picture that shows his first baseball card as a Sebastian River Little League and his Major League Baseball card. And he finished with the St. Louis Cardinals. Well, he didn't finish with the St. Louis Cardinals, but he pitched for the St. Louis Cardinals in 2011, and that's where he has this World Series ring. It wasn't without mishap. He actually tore his groin pitching actually back in Arizona against the Diamondbacks, and Albert Pujols tried to help him off the field. That was the last time he pitched in the major leagues. He finished his career in the minors. And I just want to provide some other opportunities that could happen with historic Dodgertown. This is an organization called Folds of Honor. It's run by this gentleman, Dan Rooney. The main thing that they do is to try to raise money so that they can help folks that have lost their life in our armed forces, help their children have scholarships to go to college. That's the main reason why they function. And the reason I bring that up is they're very tied to golf. They're involved with professional golf, and there's a connection there with Jack Nicklaus. And the reason why I bring that up is I've had several conversations about some opportunities that could still happen with historic Dodgertown's golf course. This is Walter O'Malley and Peter on the 9-hole course. and women were also involved in the 9-hole course, including Kay O'Malley. In 2009, a firm I was with called 4 Golf made a presentation to the city of Vero Beach and Jim Gabbard. One of the things we talked about was how the players really enjoyed having that golf course and how much of a difference it made to the African American players who could not play at any other place in Indian River County. It was a situation where even though Sweet Lou didn't play golf, he knew it had an effect on these other 3 guys that got to play. And it was a situation where he got a lot out of it because they got a lot out of it. He got to be with them after they played. This was a vision we had then, where we would utilize 3 of the golf holes to resurrect them as they were on the 9, and then utilize simulation to actually put all 9 golf holes into a simulator, in addition to putting all 18 holes of Dodger Pines into a simulator, so that in a building we could house those simulators and people could actually play the entire golf course, not only the 9-hole, but also the 18-hole Dodger Pine course in a simulation setting. When we did this proposal, it was difficult because minor league baseball had just taken over about 5 months before. So our proposal to Jim Gabbard was, I think, a good one because it still allowed minor league baseball to take and do what they wanted to with the other pieces of the property. But they were so concentrating at that point on the cloverleaf of fields and trying to figure out how to get that land done, to get those fields built, that they went ahead and concentrated on that, and it didn't really have an opportunity to consider this. So in 2011, our firm continued on in the simulation business. This is actually at the Jack Nicklaus Barbecue at the Memorial Tournament in Muirfield Village in Central Ohio. We had set up a simulator there, and we'd done a lot of work for them and raised money for a charity, and then we also changed that business into a software company and developed a Jack Nicklaus Perfect Golf Game. And we also became the official tools of the Nicklaus Design. So Nicklaus Design is also involved in a business that's in the state of Washington. It's called American Lakes Veterans Golf Course. And initially they had 9 holes. It was built in the mid-50s. They had some issues that they needed to upgrade things so that people would be able to play better, especially the people that were getting older. So they asked, and Ken Still was on their board of directors, an old professional golfer. Anybody asked, "Do you know Jack Nicklaus?" And he said, "I do." And he called him, and Jack picked up his private line, and Ken Still asked him, I said, "I need your help. We're trying to do this golf course and renovate it for our wounded veterans." And Jack, within seconds, said yes, he would. So they donated almost $500,000 in design fees to not only renovate the 9-hole course, but actually create a new 9 as well. And this gentleman to Jack's left is David Savick, somebody I actually played junior golf with in Central Ohio. I've been in touch with Nicklaus Design, and they've communicated back to me that they have interest in the project I'm thinking about trying to do here. And what happens is our wounded warriors have vehicles if they don't have legs, and they have other opportunities to play a game that kind of brings them back into regular life. And it's been a proven fact that these kinds of facilities and this situation has helped with the bad rate of suicide that's happened with a lot of people who don't get back into society when they come out of the armed forces. So one of the things that we're talking about doing is just creating 3 holes. Like I said, it's a situation where I would like to see us be able to reproduce the 8th hole, which was a par 3, kind of in the middle of the property, and it had a moat around it, almost like an island green. And then parts of the 7th and 9th holes, it doesn't have to be to exact standards, but you would have those 3 holes, and they would be able to have access for the wounded warriors to take advantage of being able to play and practice. We would also suggest having a couple of greens for putting and chipping and that kind of thing, but it doesn't have to take up a big piece of the property. Again, it's a situation where there's only been one of these built. It has to have special access for these vehicles to get into the sand traps and also onto the greens. So the Nicholas Companies is really the only company that has ever done and designed this kind of course. But they do have interest in trying to help. Along these same lines, at this past Jackie Robinson celebration game, I hosted a group up in the clubhouse above the right field fence. I put together this package for them so that they could eat and kind of be away from the crowd, but also be a part of the festivities. I contemplated it the year before, but ran out of time, so we were able to do it this time. And those people are from the Space Coast Field of Dreams, which is in West Melbourne, Florida. And it's basically a situation where they were able to come and experience the ball game, but not have to be in the crowd. And that's a terrific thing for them, because sometimes that's not easy for these children to do, for the special needs children that are involved. They got to meet and interact with some of the St. Lucie Mets, and the smiles on the faces were worth the revenue of trying to get that effort accomplished. So one of the other things that I'm saying that could be a possibility for this complex is to do a smaller version of their Field of Dreams, which it basically is for special people with special needs. That's the baseball field that they have in West Melbourne. And I just have a few other pictures of that same thing. Baseball field from that area. And you can tell that it's a turf situation so that wheelchairs or children can move around easily. In addition, they have some basketball opportunities for those same children. And there's playground. But again, this could be scaled back. It doesn't have to be big, but I've gotten the buy-in from them as far as trying to help us in any way they can, and with all the leaders that were involved in trying to get that accomplished. I'll try to sum up everything. I just want to give another alternative from the standpoint of, you know, it's a situation where this is a special piece of property. And I think sometimes, at least, it looks like the city of Vero Beach is just thinking of it from a revenue standpoint. That if they have some retail establishments there, or a hotel, or a restaurant, that they have some money that might be coming into them over time. And I just think, you know, sometimes that's really short-sighted to think of it that way, because the fact of the matter is, if Major League Baseball is not here, historic Dodgertown may not be here. So there are other opportunities, and they could be revenue-based. There could be a revenue base in either of these. There are other situations where there could be revenue coming in still, if that's their main reason why they're considering this developer versus what Indian River County has to offer. So I just wanted to let you know that I've talked to Colonel Marty Zickert. He's very much interested in trying to help with any volunteers that are needed for a situation like this. The American Lakes Golf Course in the state of Washington is totally run by volunteers. There is no outgo as far as any expenses for employees on that golf course. It's a situation where, with the help of the Indian River County Veterans Council that he's head of, that they would have a very big participation from the standpoint of they have an awful lot of guys who want to do things, but there's really nothing physical for them to do. So this is a way to try to help our wounded veterans. And the Indian River Field of Dreams is a way for us to help handicapped children. So I do believe there's other opportunities too, for revenue opportunities, if that's what is really needed to make this deal happen with the city of Vero Beach. But I just wanted to make sure that they knew there are other opportunities for this property.
Great. Thank you very much, Fred. Some great photos you had there. Thank you. Anyone else from the public wish to comment on this? Okay. Commissioners, we have a proposed agreement for sale and purchase before us. I would like to see us approve this now so that we have it in hand at the City of Vero Beach October 2nd meeting.
Mr. Chairman, move approval.
Thank you. We have a motion from Commissioner Flesher, second by Commissioner Adams. Any further discussion on the board?
Mr. Chairman, I just want to say, you know, it'd be in a greater place. It'd be great to just increase this to a phenomenal number that we know that we were going to come home with the trophy. But I believe that there was great interest during the council meeting, and that's what had stalled the decision. One of the things that were pointed out, which I think that many of our community members and people of interest, and Fred, thank you so much for that presentation, was pointed out that, you know, a lot of other things can happen, and the county can flip this, or there's still no prohibition that a building could be made. I only hope that today was just an indication of the canvas is wide open. We still have to talk with Major League Baseball, and there might be other visions brought to the table as well. I appreciate the visions that were brought today, but at least they have an indication that this will be part of a legacy and a solution. And quite honestly, what was brought up is that they might be looking for a revenue-based decision. If Major League Baseball comes into this town and brings that vision to reality, I think that any tax-based income from a hotel will be paled greatly by the element of tourism, the element of participation and excitement. And we often talk about being placed on the map. I don't think there's a pin big enough for the map if Major League Baseball has a full, both oars in the water buy-in to historic Dodgertown, what happened into historic Dodgertown, and what could happen to what was formerly known as the 9-hole golf course. And I believe we're here probably sitting, we might be sitting in the audience of something that's about to happen that is great, probably as great as what happened over 60 years ago. And it could mean a lot for our community, for the city of Vero Beach, for the citizens of this county. So I'm quite excited. Only wish we can almost guarantee the sale, but I only hope that the council members that are making this decision weigh into the fact of the great community input and the amount of results that can happen if they cause for pause and think it's not all about dollars, that there's a greater form of currency that's being wagered. Thank you.
Thank you. Any other comments? Seeing none, all in favor of the motion signify with aye. Aye. Any opposed?
Nay.
That motion carries 4-1 with Commissioner Solari opposed. Thank you all for your input. Thank you. We move to departmental matters under C, General Services. Notice of Hazard Mitigation Grant Program Award from Hurricane Matthew for the Oslo Riverfront Conservation Area. Do we have Beth Powell, or Beth, are you leading this off? Okay, great. Good morning, welcome.
Good morning. Thanks, Scott. Good morning, Commissioners. It was June of 2017 when we brought this grant to you. So hurricanes come through quickly, and the processes to recover for them generally take quite a long time. So I'm looking forward to giving you the presentation that we have today on Oslo Riverfront Conservation Area. This is a hazard mitigation grant program that we applied for. I'd like to thank Etta Lopresti and at the time John King and now Todd Stone for their support and assistance. I think they handle all of the local mitigation strategy stuff, and it's a big endeavor. Oslo Riverfront Conservation Area was the #1 ranked project, and here in a moment you're going to get to see exactly why. Scott, can you put that on the... That's okay. So one of the, just some background on Oslo Riverfront Conservation Area for those that may not be aware or know. It was purchased in 1995 with cost share funds from St. Johns River Water Management District. It is one of our oldest conservation areas. It's 298 acres. It's open to the public for passive recreation with hiking trails. And then it's also adjacent to what we call South Oslo Riverfront Conservation Area, which is another several hundred acres to the south. This particular property is located adjacent to South Vero Squares Shopping Center, Forest Park Subdivision, the UF Florida Medical Entomology Lab, and it's just east of US Highway 1. Our habitats are various. They include mature maritime hammocks, scrubby flatwoods, mangroves, and estuarine wetlands. Just for purposes for location, you can see here on the map, it's west of the Indian River Lagoon. It actually has quite a bit of acreage along the lagoon, and then east of US Highway 1. And then you can see the larger, South Oslo Riverfront Conservation Area, which creates the larger complex as the Oslo Riverfront Conservation Area. Just to give you an idea of what would happen if we had a drought situation and a wildfire in this particular area, you can see I've put a buffer basically of the area that would be most likely to be affected by a wildfire. And you can see 1,000 foot and then a 25-foot potentially affected area. Again, the direct threat to the homes in this area, as you'll see from some future slides, is pretty intense. In the event that we had some type of situation where we were under extreme drought conditions and then had a lightning strike in one of the communities that would be more hazardous and susceptible to fire, although all communities in a drought situation are susceptible to fire. And so you can kind of, this just is a visual, the smoke, if we had a south wind or a southwest wind, or even a southeast wind, would affect even the homes outside of that 2,500-foot area. Those areas, that's Vista Royale, which has a community of older population, many of which would probably be affected from a health standpoint from lingering smoke effects if we were to have a wildfire. This is just another close-up so that you can see the actual houses. All those little dots are houses, the road, and then the golf course there. So it's hard to come to a commission meeting and get the scope of what our habitats and our wildlands look like in our urban interface. But what I'm going to do is take you through a series of 3 slides. This one first, just on a blip, you can see the third house to the, that would be to the west, the third house to the west. You can see the vegetation line along these homes. Yep, thanks, Scott. You can see the vegetation there, and then you can see another little blip just south of that. So what I'm going to demonstrate here, you can see the blowdown that we have with the sort of a lighter gray color, and then you can see a stand of larger Australian pines up in the corner on the east side. This area has always been problematic. Our access to this area is extremely limited. There's actually no way to get into this area that we're looking at right now, except through private property, going through the homes themselves. And so you can see there's a lot of vegetation there, and a situation with wildfire, we would be looking at a pretty dire situation for these homes. We just don't have the ability to get equipment in. Here you can see, this is the second close-up shot, and you can see again the proximity from the wildland interface to the homes is very close. And then from this slide, you can actually see this is less than 13 feet from this roof line here to vegetation. And what we're proposing to do, and what we've proposed through this grant, is to create an initial 100 to 150 foot cleared zone from the property line, which is approximately where the yellow lines end in the top case or begin in the bottom case. And to create an actual cleared area, we'll work around native habitat, native trees and things like that, anything that's sensitive, but generally to open up and to get rid of all the debris, and at least just to get it down and mulch to the ground. This is another example. This is on that the southeast corner there. You can see we've had, not only have we had Hurricane Matthew and Irma, but we had extensive blowdown in Hurricane Jean and Francis. And all that material is still there. So you might have new growth over top of it, but the actual dead material is still on the ground. And that's part of this grant, is to remove all of that. So our request was submitted in December 2016. The cost estimate at that time was $65,000. This grant is a 75%, 25% match. So the grant will provide $48,750. The county match is $16,250. So good bang for our buck in this particular situation. Again, it's to provide 100 to 150 foot cleared zone, initial cleared zone, which will then be broken down into an established fire break of approximately 15 to 20 feet over time. Again, sensitive vegetation will be avoided, and our property boundary has been established by survey. And one of the things that we'll be looking at in the future is being able to maintain that property line in the future with fencing. All of our conservation areas have been marked on the property boundary so that we know exactly where the county's property begins and where private property begins. And some of the problems that we've had in areas all over the county is landscape and lawn encroachment, which we've sort of passively allowed over time. In this particular situation, because the fire threat was pretty significant, but then now is going to be a good time to reestablish those lines and to be very clear with our homeowners. We did have a lot of homeowner support. We had, I think it was 16 letters. It's in the back up here. I think it was around 16 to 17 letters of support and one asking for clarification. So we had a lot of support, homeowner support, and we've been communicating with the homeowners, and they're anxiously looking forward to this project. I'd also just like to point out that we did finish the countywide wildfire mitigation plan. This was a plan that we were authorized to proceed with. That particular grant is still under review at this time, and we are hoping that we will get funding for that. That's a series of different projects that we will be conducting throughout the county, and we want to remind everyone to pay attention to FireWise information, because by the time you're in a drought situation, it's generally a little bit too late in order to realize that you have a problem, that you need to be maintaining your FireWise safety zones. And if anyone has any questions, they can feel free to contact us. And we continue to work with the Florida Forest Service in the interim until we find out about the funding for the countywide HMGP grant. And I'm happy to answer any questions if anybody has any comments or questions.
Very good. Thank you, Beth. Commissioners, any questions of staff? There is a recommendation that we move forward with the grant.
Move staff recommendation.
Second. We have a motion from Commissioner Solari, second by Commissioner Adams. Is there anyone from the public that wishes to comment on the motion before us? Seeing none, all in favor signify with aye. Any opposed? That motion carries 5-0. Commissioners, we have a couple folks from Republic here that have been waiting very patiently, or actually have they stepped out? No, okay, I was going to move them up, but well, if they step back in, I'd like to move them up so they can get on to work, but we'll go ahead and move on to Public Works, Arabella Reserve Developers Agreement. Mr. Spirka, welcome.
Commissioners, Rich Berg, Public Works Director. What I have before you today is the Arabella Reserve Developers Agreement. It's a partnership with the county and GHO Homes, the developer of Arabella on the southeast corner of 49th Street and 58th Avenue. It should be noted that in the Gifford Neighborhood Plan, it identifies some improvements, intersection improvements on 49th Street and 58th Avenue to signalize that intersection and provide turn lanes. And as part of the Waterway Village Developers Agreement from 2004, Waterway Village is required to four-lane a section of 58th Avenue from 49th Street to 53rd Street. As part of that, they are not required to acquire right-of-way that is not under their control. Basically, they've donated all the right-of-way that fronts 49th Street to the north, fronts 58th Avenue on the east side of 58th. but they were not required to go out and purchase right away that isn't under their control, property that isn't under their control. Arabella Reserve, being on the southeast corner, has a right of way, is donating a right of way to the county as part of this developers agreement, or we're purchasing the right of way on the corner for the Waterway Village design and permitting of the improvements to 58th Avenue. Arabella Reserve is providing us with design and stormwater capabilities within their development. They're going to take the stormwater off of that section of 58th Avenue. They're going to donate 67 feet of right-of-way, about 1.08 acres to the county for the widening of 58th Avenue that fronts their property. So at the end of the day, this is a cost benefit to the county as the right-of-way, we're purchasing the right-of-way, we're able to get stormwater from them. They're permitting the stormwater treatment and discharge into the Indian River Farms Canal. So funding is available for $83,226 in the secondary roads right-of-way, 58th Avenue and 49th Street budget. Staff recommends the board approve the developers agreement between the county and GHO Arabella and approve the funding in the amount of $83,226.78 and authorize the chairman to execute the developers agreement on behalf of the board.
Thank you, Rich. Commissioners, any questions of staff? Commissioners, your pleasure.
Move staff recommendation.
We have a motion from Commissioner Fletcher, second by Commissioner Adams. Is there anyone from the public that wishes to speak on the motion before us? Seeing none, all in favor signify with aye. Aye. Any opposed? That carries 5-0. Commissioners, if everybody's okay, I'd like to move up the Solid Waste Disposal District Item 2, the 11th Amendment to Republic Services. This is the Hurricane Preparedness Plan. Morning, Vinny.
For the record, Vincent Burke, Director of Utility Services, and I have Himanshu Mehta, who's the Managing Director. Short four-slide presentation. We'll run through this and see if you have any questions, staff, or Public Services. As you know, we came to the board before with respect to the customer convenience centers during the past storm event. I think folks kind of got nervous, got the word out, and so they inundated some of the convenience centers with a bunch of material, everything but the kitchen sink, so to speak. And in doing so, there were a lot of material placed at the customer convenience centers right before the Hurricane Irma was supposed to hit and landfall. As a result of that, Hurricane Irma did come, but then the centers were actually full of material. And so staff is trying to look at a way that we can proactively manage this process, but not be putting ourselves into a situation. So we have a draft closing plan that we'd like to run by the board and seek approval for with respect to closing down to those centers, at a certain time and location to be determined with Republic Services and the county staff, so that we can clear out some of that material so that when the hurricane blows through and we get the okay from Emergency Services and Public Works, we then have two of our largest centers cleaned out and ready to go. So what we are trying to do is to not really nail something down, because as all storms can shift and change based on some of the dynamics that are outside of our control, is to kind of put a timeline together with respect to working with Republic Services. If you recall last time too, we had certain centers that are closed during the week, and we had to keep those open, so there were additional time and effort to try to manage this process. But for instance, like Roseland Road, which is a very small area, in some cases, Republic Services had to stay in the queue for almost 45 minutes to an hour just to get the truck to the location to be able to pick up that material. So it was a safety issue, and it was a stacking issue. So real quick, just to run through this, what we're looking at doing is tentatively closing the large two centers, Oslo and Fellsmere, at some point, perhaps 48 to 72 hours before landfall, in a way that allows Republic Services to focus on those centers, to clean those centers out, empty the containers, remove some of the goods that are on the property. They don't turn into projectiles, but keep the remaining convenience centers open. That would be Winter Beach, Roseland, and Gifford, so that we can still let folks use those centers, or they can even come down to the landfill to drop off some of the material. We would work with Waste Management and Republic Services with respect to suspending garbage and possibly recycling collection, take down the tarp, which we've done in the past at our MRF facility at the landfill. And then at some point, due to the safety concern for not only our folks, but also for Republic Services, we look to shut down all the convenience centers and the landfill, get it prepped, make sure we have rock base ready to go in case we have heavy rains and or side slope erosion on some of the travelways to the open face of the landfill. And then after storm, we'd kind of flip-flop with the convenience centers. We'd have, obviously, Oslo and Felsmer open, ready for business. We'd open those centers up, assuming we can get staff from Republic here safely. We would then shut down those 3 other centers and clean those out. And be able to then handle the traffic sometime between 12 to 24 hours after that storm goes through, and then obviously focus our efforts on the other centers to get them cleaned out and ready to go. So we have an attached an amendment for consideration that includes some language with respect to operation maintenance. We, as you know, have a current tip fee of $13.25. There's a CPI increase that goes into effect next calendar year. But we'd certainly have been told by Republic Services that there are some additional costs above and beyond our existing contract that may come into play with regards to mobilization, rental of additional equipment, material perhaps that might be needed. Rock base is included as an example, and those costs would be determined with sufficient documentation presented to staff for review. At the convenience centers, there may be some additional folks required to come on if we choose to open those centers say after the storm comes, so that we can accommodate our good folks and our customers. And so Republic is looking for a $41.99 per hour per person charge. That would be above and beyond some of the normal services. So if you looked at the backup, you'll see that we pulled some of the tonnage data with respect to the last 6 months, so that we can have a good baseline of estimate to say, okay, if we have a snapshot in time of what our normal tonnage is coming from the centers, we are then able to look at what that cost increase would be for any differential above and beyond. So part of that includes additional personnel that Republic Services would bring on, but also some additional material cost to move the additional material, which is set at about $17 per cubic yard, with a disclaimer that there are plans to do some negotiations. And what happens is, when the storm comes, resources are limited. And so when you have a big storm like Hurricane Irma that reached pretty much from the southern portion of Florida all the way up to Jacksonville, those finite resources sometimes get allotted elsewhere. In terms of trying to secure some folks here, there are sometimes negotiations in terms of personnel, manpower, and equipment that need to be reserved. And sometimes that varies based upon the storm. So right now we have a placeholder of $17 per cubic yard that we've negotiated with Republic Services in good faith, but certainly there's some language that does allow some additional negotiations if market conditions change based on some of those resources. So what staff is recommending is that the board approve the 11th Amendment to Republic Services to provide additional services for the non-Class 1 landfill services, including the customer convenience centers, in response to any potential hurricanes, and authorize the chairman to execute the same as presented. Certainly available for any questions, myself, Manchu, and Joanne Stanley from Public Services.
Thank you. Any commissioners, any questions of staff? Commissioner Solari.
I just have one comment. I think this is an excellent plan and will do a lot going forward. I'd only suggest that you immediately start informing the public of what you're doing, and then develop a program next year that starts maybe 30 days prior to the hurricane season, where you do things like have clear announcements at the convenience centers, and also run public service TV things on our channel, and just try to get the word out as much as possible, because I don't think that most people are going to really internalize these changes until shortly before a hurricane. So it's going to take, I think, a reasonably aggressive public announcement program to get the rest of the citizens familiar with what the new procedures are going to be. And with that, I'll be happy to move staff recommendation.
Thank you. This is under item 15B2. We have a motion from Commissioner Solari, second by Commissioner Adams. Is there anyone from the public that wishes to comment on the motion before us? Joanne, you're good? Very good. All those in favor of the motion signify with aye. Any opposed? That motion carries 5-0. Vinny and Himanshu, thank you. Republic, thank you for all you're doing.
Do we go one more SWID item?
Yeah, while you're here, that's fine if it's good with the board.
Move staff recommendation for B1.
We have a motion for 15B1 from Commissioner Slaughter for staff recommendation, seconded by Commissioner Flesher. Any discussion? Anyone from the public wish to comment on the motion before us? Hearing none, all in favor signify with aye. Any opposed? That motion carries 4-0. Commissioner Adams having temporarily stepped out. Thank you. Vinnie, Himanshu?
I just want to say quickly, thank you to Mr. Katz. He's been a great partner since 2015 in servicing our single stream material. I do want to just point out in the agenda packet that there might be a future consideration for the board. I just want to bring this up as a procedural issue. Mr. Katz's extension would then add 2 additional years to the original 5-year term, which would coincide with 2022. However, we are currently in the first 7-year term with Waste Management, and the board will need to consider a year in advance on September 30th, 2021, whether or not to exercise that 3-year option to renew. What staff would present if at that time in 2021 is perhaps also aligning the single stream processing, which would then expire in 2022 after the decision today, to maybe align with the hauler's contract extension. So at that time, we'll bring it up. I just thought it would be a good placeholder in this agenda item to notify the board at that time. Thank you.
Very good. Thank you, Vinnie. Then we go back to 13, County Attorney Matters, Item A, preliminary legislative list for 2019. And Ms. Kate Cotner, good afternoon and welcome. Oh, no, good morning still. Quick.
Still good morning. All right. So for the record, Kate Cotner from the County Attorney's Office. Between September 26th and September 28th next week, the Florida Association of Counties is having a policy conference. So in preparation for this conference, the County Attorney's Office put together a list of legislative concerns. This is just a preliminary list. This is not part of our legislative agenda or our package. We'll put that together probably after the elections and bring it before the board. On here, you're going to find some of our usual suspects, including vacation rentals, affordable housing. Some new ones on here that I just want to make you guys aware of is biosolids, which is something the board has discussed in the past. It has 2 options. One is to limit or ban biosolids within actually the watershed that would make up the St. Johns River, but there's also the option of banning it altogether in the state of Florida, first by limiting it and then an outright ban, which has been put forward by the Treasure Coast Regional Planning Council, and this board took action to approve a resolution in favor of that. There's also on here about the 2020 recycling mandate. Some new things, though, that I want to kind of draw your attention to. One is legislation relating to a green utility ordinance. This is something that we've been working with our land conservation manager, and it's supported by, let's see, Monroe County and Palm Beach County. And what they want to do is they want to expand a piece of a statute to basically allow for extra funds to be used for land conservation and also to remove nuisance exotic and native species. So it would just basically allow us to have an additional funding source to remove nuisance plant life from our conservation areas. This can be done either by a referendum or it can be done voluntarily on a utility bill, so a resident can go ahead and voluntarily check the box. Another thing that's on here is legislation related to customary use. As you know, we're going to have a hearing in the future, but there's 2 options. One is just to repeal the legislation altogether that was adopted last year, or to just modify it such that that judicial review, that secondary de novo judicial review is removed. And so the final determination would be with the board, and if there's an appeal, it would be done like any other ordinance, which is to go with a writ up to the circuit court. Some other ones that are on here is the basically legislation related to the funding of the school resource officers concerning the Stoneman Douglas High School Public Safety Act. If you recall, this is something that is a problem or an issue statewide with just the funding of this safety act. And so we're trying to come together with the school boards as well as the Sheriff's Association to put forward to the legislature, hey, the school board needs more funding, whether that comes with a millage raise, whatever they deem to be appropriate, but we're just trying to join forces with our community to make sure that appropriate funding is there. Another one is legislation related to assisted living facilities and nursing homes. We've done extensive research on this issue. So the nursing homes is really monitored, and the plans are reviewed by ACA. But when it comes down to assisted living facilities, it's really up to the locals to make sure that it moves forward with the building code as well as the fire code. But there doesn't appear to be any teeth for when people do not comply. So it's something that I think a statewide issue, people are going to want some teeth. And finally, and I'll leave it alone, is just legislation related to the funding and reimbursements associated with hurricane shelters. I know this is an issue we have all discussed. At this point, we're responsible for getting FEMA reimbursements, and there needs to be some sort of an oversight or plan moving forward. So,
Thank you. Kate, one question I have on the biosolids, and probably I should have brought this up prior to, but it's my understanding that down in the Lake Okeechobee, the Caloosahatchee River, and the St. John's, or the St. Lucie River watersheds, the legislature didn't technically ban biosolids. What they implemented was that they had to document a net negative phosphorus input, and that no one could document that, so therefore it became a de facto ban. Should our policy then be to follow that same path, or do we want to just look for a ban and say just ban it regardless?
that truly is up to the board, however you'd like to move forward, because I'm sure we'll be working with legislative sponsors in drafting something.
Would it be easier to get the state to go along with that if we're just using the same policy they've already implemented?
We certainly could, because then it leaves the door open, I guess, for if there ever is a facility that would qualify. Human waste is a statewide problem, and the state's gonna have to address it. And I think now is an opportune time for that conversation. So to answer your question, we could do it either way. It's whatever the board's pleasure.
And just, Commissioner, sorry, yeah.
On that, Representative Graw's office is very much engaged in this issue, and I think which way we end up going ought to be determined in concert with her office, and ask what she believes would be the path forward with the greatest possibility of success. And then, is anybody here got biosolids issue on any of the FACT committees? Because you do, I mean.
Yes,
so,
I submitted it, and it'll be under the growth management.
But who's on that board here? So, I mean.
I think both of us are.
Okay, so, I mean, then your feedback, based on, say, what FACT says and what type of support we get from around the state, I think would be crucial in determining which way we'd want to go.
So, I only just kind of brought this up, but I'm fine with leaving it how it is, and then we can just kind of see where the direction goes and work with Representative Graw's office and kind of go from there. But
sure.
I think eventually, we're all solid on what we want done, just the wording wise.
Sure, and we can actually change this if you would prefer to say policies that restrict or ban. So at least it broadens it out a little bit more, and that gives you more leeway with what the FACT discussion might take place next week. Is that something?
Restrict or ban, I'm fine with that.
Okay. Not a problem.
Anybody else opposed from that on the board? So we go to restrict or ban, okay. Commissioners, anyone else have any comments for Kate on this?
Not on this particular one, but just in general.
Right, yeah.
What other policy proposals were submitted from the county to FACT? Do you know?
So we submitted two. One was on biosolids and one was on recycling.
Okay.
We did not need to submit anything on SHIP funding, because that is an overall policy that the FACT designates every year. And someone had also already submitted something on the school safety measure as far as that collaborative effort. One thing that I will follow up after this meeting and after the board makes a decision is on the customary use. I want to make sure that they have that on their radar.
Thank you.
Yeah, no problem.
Okay. Anyone else, commissioners? So staff is recommending that we adopt the 2019 preliminary legislative list of concerns. I'll be glad to second the motion. Okay. We have a motion from Commissioner Adams, second by myself. Any discussion? Anyone from the public wish to comment on the motion before us? Seeing none, all in favor signify with aye.
Aye.
Any opposed? That carries 5-0. We concluded commissioner matters earlier. We've concluded special districts and boards. Commissioners, anything for the good of the community? Seeing none, we're adjourned.